My lord, may I have your lordship's leave to mention in regard?
Can we have the mentionings tomorrow? We are already late by 1 hour. There was a swearing in ceremony, you're aware. I'm late by 1 hour. So can we have the mentionings tomorrow, please?
Lordship.
There's a specially fixed matter also at 11:30 like that. Yes, Jalpaiguri Circuit Bench. Mr. Dev for the other side. There was a direction for demarcation, Mr. Dev. হ্যাঁ আপনার জমি ডিমার্কেশন হয়েছে আলাদা করা গেছে আপনার জায়গা আর ওদের জায়গা
My lords,
I have already given the copy to my learned friend, my lord.
my lordship, demarcation হয়েছে ফার্স্ট 16 তারিখ
Present
জানুয়ারি মাসে।
demarcation?
ইয়েস মাই লর্ডশিপ, ফার্স্ট ডেট 16 তারিখ দেওয়া হয়েছিল জানুয়ারি মাসে। সেদিন ওনারা এসেছিলেন 2:30 নাগাদ। ওদিন জাস্ট পয়েন্টিং সামান্য করে চলে গেছেন। ইভেন ওদিন রেসপন্ডেন্টরা এসে একটু বাধা বিঘ্নও দিয়েছিলেন। আর নেক্সট আরেকটা ডেটে এসেছিলেন, সেটা 31 তারিখ, আর ওদিনই ওরা কমপ্লিট করে যান। ওনারা দুপুর 12টা নাগাদ এসেছিলেন আর 4:30 নাগাদ গিয়েছেন। আর সেদিনও মাই লর্ডশিপ আমি একটা জিনিস জানাতে চাই, এই যে রিপোর্টটার মধ্যে যে দিয়েছে, রিপোর্টে কিছু কিছু জায়গার যে পরিমাণ দিয়েছেন যে আমার পজিশনে আছে, সেটা কিছুটা মানে কিছুটা 19-20 আছে। মানে
আপনি ছিলেন তো তখন যখন
Yes,
এটা
my
করা
lordship.
হয়েছিল then?
ইয়েস মাই লর্ডশিপ, আমাকে আজকেই আমি এই কপিটা পেয়েছি স্যারের কাছ থেকে। এর আগে আমাকে কিছু জানায়নি, ওনারা ওনাদের মতো
আপনি
করে
কি
গেছে।
এটা ভালো করে দেখে নিয়ে আবার আসতে চান আরেকদিন
ইয়েস
দেখে
মাই
করতে
লর্ডশিপ,
চান?
কিন্তু মাই লর্ডশিপ আমি এখানে এটাই জানাতে চাই যে এখানে আউট অফ ডিক্রি ল্যান্ডও এখানে দেওয়া হয়েছে। মানে যেটা এই কোর্টের অর্ডার ছিল ডিক্রি ল্যান্ডের উপরে, আর ওনারা আমার টোটাল ল্যান্ড দিয়েছে, সেখানে অনেক মিস্টেক আছে, এমন এমন দাগও দিয়েছে যেটা আমার আন্ডারে আমি জানি যে নেই। বা আমি এটার অপোজিশন আমি কিছু ডকুমেন্টস এর সাথে দিতে চাই, আমার খতিয়ান, আমার দলিল, ইভেন আমার
আপনি
বাবা
একটা
যাদেরকে
এই
দিয়েছে।
রিপোর্টার একটা এক্সেপশন ফাইল করতে চান
ইয়েস
তাই
মাই
তো?
লর্ডশিপ, ইয়েস মাই লর্ডশিপ,
কবে করবেন বলুন?
মাই লর্ডশিপ আগামীকাল।
আসতে পারবেন আপনি এত
ইয়েস মাই
তাড়াতাড়ি
লর্ডশিপ,
রেডি করতে
দুটোর
পারবেন?
সময় মাই লর্ডশিপ, দুটোর সময়।
রেডি করতে পারবেন
ইয়েস
আপনি?
মাই লর্ডশিপ পারবো। মাই লর্ডশিপ আগামীকাল 2টোর সময় ম্যাটারটা রাখেন, যাতে আমি একটু
Demarcation report submitted on behalf of the alleged contemners is taken on record.
And the report of the contemners also.
Yes.
There are 2 reports. I filed 2 reports, my lord.
মাই লর্ডশিপ আমি আরেকটা জিনিস জানাতে চাই। অ্যালেজ কন্টেম্প নাম্বার 4 অনিন্দিয়া ভট্টাচার্য আইসি, যিনি উনি ট্রান্সফার হয়ে গেছেন আমাদের আলিপুরদুয়ার থানার থেকে অন্য থানায়। এখন আপাতত মানে উনি আমার এই ম্যাটারে আর
করতে পারবেন না। আপনি এক্সেপশনটা ফাইল করুন।
ইয়েস
আপনি কদিন আছেন এখানে? আমি তাহলে একটা অন্য ডেট দিতাম।
মাই লর্ডশিপ আমি আছি, 2 দিন আছি মাই লর্ডশিপ, আগামী পরশুদিন চলে যাব।
পরশুদিন ফিক্স করে আমি তাহলে ম্যাটারটা, আপনি একদিন হাতে সময় পাবেন, সেই জন্য বলছি। Let it appear day after tomorrow.
Any day, my lord. I have nothing to say, my lord. If you want to.
আপনি কালকে চাইছেন এটা?
ইয়েস মাই লর্ডশিপ।
If you can, my lord, I have no any.
Demarcation reports submitted by the alleged contemners are taken on record. Paragraph, the petitioner seeks to use an exception to the reports. Paragraph, let the matter appear under the same heading on Kalke date din, marked at 2 p.m. Seven.
Grateful, my lordship.
Yes, days list, please.
Matter fixed at 11:30.
Yes, yes.
Mr. Mishra is.
Yes. The specially fixed matter.
Yes, matter, kindly. স্যার আবার একটু ডিস্টার্ব, সরি, এই জন্য ক্ষমা।
আরে তোমরা করো, আমরা জানি তো, সেই জন্য তো। এই নাও নাও, তোমরা ভালো করে করো, আমরা 12:30টায় আসবো। হ্যাঁ হ্যাঁ।
ওইগুলো বের করে দিই। হ্যাঁ, হ্যাঁ, হ্যাঁ।
I'm not going
সময় নেব, একটু সময় নেব, আজকে শেষ করুন দেখুন।
Yes,
Please,
Mr.
Your Lordship. My Lord, I have been listening Your Lordship on the question of jurisdiction. Now, my Lord, for Your Lordship's convenience, I have prepared a short note. Exactly what I have argued, I have prepared, and I was citing some decisions of Your Lordship. I shall place those decisions. Well, may I hand up? This Your Lordship can treat it as a sort of refreshing Your Lordship's memory. হ্যাঁ, তা দেবো, সবাইকে দেবো। এসছি যখন তখন ছিল। এইটা ওদের দল। Well, if I may just place it very quickly, the first point is lack of jurisdiction of the writ court to entertain the writ petition. The subject matter of the controversy is the Motiabag Palace.
My lord, whether your lordship will hear on preliminary point or on merit.
Preliminary point.
Preliminary point.
Preliminary, my lord, then he cannot reopen
No,
this case. In view
since
of the
he's
latest
challenging
decision-
the
in view of
jurisdiction,
the latest decision of the Supreme Court, whatever arguments is being rendered, that is counter to the object of the law.
You
That is the
give
purpose
answer
of-
after I made my
having
submission.
an opportunity, sir.
So preliminary question, my lord, I have the submission.
Since the preliminary
My
issue has been
preliminary-
raised, the Mr. Mitra will have
He
the
runs
first right of
counter to the
audience.
principles of law initiated by the Supreme
Very
Court.
well, we shall see that. We
Since
shall-
it's a question of
Then the
jurisdiction,
pleadings are complete, my lord. He cannot be permitted, my lord. This is my submission, my lord.
Very good.
This goes in Supreme Court recently, it goes runs counter to the object of the law of the procedure.
you will have your chance to reply, sir.
Yes.
Let us hear this.
আপনি চান্স পাবেন, ব্যস্ত
So,
হচ্ছেন কেন?
No, no, that's why, because it is my duty
Huh.
to raise the point.
You
What
have raised the
already
point.
decided by the Supreme Court, he
Please
can.
place the judgment, I'll go through.
Yes,
Please place the judgment, I'll go through.
Mm.
Yes, please continue, Mr. Mitra.
কি জাজমেন্ট আছে প্লেস করবেন? জজ সাহেব কি বলছেন?
You are referring to a Supreme Court judgment.
Yes, my lord.
Please place the
Yes, yes,
judgment.
my lord.
কোথায়?
I can. That is just. I'm showing. Satyanath versus the Supreme Court. Satyanath. No, Supreme Court. Yes. Argument of the-
না না ঠিক আছে, ঠিক আছে।
Yes, the relevant paragraph.
Your lordship kindly see
This is with regard to res judicata.
32 to 34. At page, the paragraph 32 to 34, 33, 34 of the judgment. This question was raised, the primary question.
This is with regard to res judicata.
Yes, no, my lord, here, your lordship already 9, after taking into consideration the submissions of the party, your lordship granted interim relief to the parties. Interim leave, that means, my lord, your lordship directed the parties to maintain status in
Yes.
respect to the suit letter. That relief
That was
once
upon both the
Yes, my-
parties.
that relief was granted by your honor. Now, my lord, they are entitled to raise this question again. When they did not raise
Where
the
is the,
question,
where is the
when they did
bars?
not raise the question earlier, they had the first opportunity. Because order 21 given the chance to raise the question. Order 14 also given the chance to raise the question. They missed the bus. Now they cannot. My lord, miss is a miss backed by three. Miss
As
is a
far
miss.
as I can recall,
Miss
I'm
is a
sure
miss
you can
backed
also
by three
recall,
words.
this question of maintainability was raised at the first instance by them.
Here, my lord, they check, then your lordship already assumed what raised.
Please, sir, please.
Your
It
lordship
was
already,
raised at the first
your lordship
instance.
already assumed jurisdiction over the matter. On the prayer made by the parties, they surrendered before your
Sir,
lordship.
let Mr. Mitra complete. You will have your chance of audience.
Let me answer you. On this point first, let me answer this and satisfy your lordship and satisfy my learned friend also. I think it is my duty also to satisfy my learned friend. Well, this particular judge decision, kindly similar, this is an Article 227, this is a revision petition. Kindly see the first paragraph. Is under Article 227 of the Constitution of India and my lord, paragraph 32, 33, 34, Order 41, Rule 24, 25. Well, these are got no application at all. My lord, just to answer this particular issue, Lordship will be pleased to take, my lord, the judgment of 1994 4th Supreme Court cases, page 711. This is the judgment I was going to cite. But first I meet this point and then, my lord, I go into other things. Lordship will be pleased to take. এই আমাকে আমার বইটা দাও আরে বইগুলো দে 1994 4th Supreme Court cases 711. This is a judgment of 3 judges bench. Well, this was given by Chief Justice Venkatacharya, Justice Amedi, and Jivan Reddy. At this very point, 1994 4th Supreme Court cases 711. Well, it is a torn book. I'm copy আছে দেখো দেখো Good. Ashford Boys. Judgment. Well, may I hand up to your lordship, my lord? Rather, your lordship is
Yes,
given.
please.
Kindly come to paragraph 14. This completely answers my learned friend. This is what the Supreme Court. Before
Yes.
we part, we must clarify that we have confined ourselves to deciding whether on the averments made in the petition, any part of the cause of action is shown to have arisen within the jurisdiction of the Calcutta High Court. Even if we had come to the conclusion that the averments disclosed that a part of the cause of action had arisen within the jurisdiction of the said court, and therefore petition could be entertained by that court, it would still have been open for the opposite party to dispute the said averment. And if the opposite party were to succeed in showing that the averments were not true and correct, the petition, though entertained, would fail for the want of jurisdiction. This completely answers my learned friend. And this is on 226.
Please give me a copy of this, a photocopy.
Copy name.
I shall do so.
Well, if I may come back to my note.
Yes.
Because, my lord, as I submitted to your lordship, that it goes to the inherent jurisdiction of the court. If the court does not have jurisdiction in terms of Article 226, 1 and 2, then, my lord, it is bereft of jurisdiction. And if that is pointed out at any point of time, the court is entitled to take note of it, and the court can, my lord, decide on the issue. Lack of jurisdiction with court. The subject of the controversy is Matiabad Palace, which is also known Hawa Mahal, situated at Gauripur town, Dhubri in Assam. In the said writ petition, the writ petitioner has prayed for mandamus seeking to set aside the alleged notification dated 10th October 2022, issued by a Director of Cultural Affairs, Assam. Writ petition, page 80. To be noted is that this document is not a notification. It is merely a communication. My lord, your lordship can keep the writ petition, my lord, open at this stage and see, my lord, this document at page 80, which is the subject matter of challenge in this. Page 80 is merely a letter communication from Director of Cultural Affairs Assam at Guwahati to the Deputy Commissioner Dhubri. And my lord, this is with regard to what? That 15 crores of fees is to be paid. That's all. So I have written, to be noted is that the document is not a notification. It is merely a communication with the Director of Cultural Affairs, Guwahati, Assam, to the Deputy Commissioner Dhubri in Assam, intimating that rupees 15 crores was going to be released in favor of the Deputy Commissioner of Dhubri for acquisition of land at Matiabag in connection with the developing the house of late Pratima Bodua Pandey at Dhubri. Under Article 226(1) of the Constitution of India, the Honorable High Court, within whose jurisdiction, within whose territories, it should be the government, not and. The government is located, whose order is sought to be challenged by the writ, has been empowered to exercise jurisdiction. Thus, under Article 226(1), the impugned document having been issued by the government of Assam and the territory within which that government is located, namely the state of Assam, the Honorable High Court at Assam would ordinarily have jurisdiction to entertain the writ petition. However, under Article 226(2) of the Constitution, which was brought in by way of amendment, any High Court within whose jurisdiction the cause of action, wholly or in part, arises, has been empowered to exercise jurisdiction to issue directions, orders, or writs to such government or authority. In terms of Article 226(2) of the Constitution, the writ petitioner would be entitled to maintain the instant writ petition in this honorable court only if it could satisfy that the cause of action in the writ petition has arisen either wholly or in part within the jurisdiction of this court. In other words, unless the writ petitioners succeed in showing that the facts pleaded in the writ petition constituting cause of action, partly or wholly, has arisen within jurisdiction of this court, the writ petition will fail. Furthermore, as was pointed out by the Supreme Court in 2002 Supreme Court case, I shall place this judgment, page 567, paragraph 14. Such facts must be connected with the relief sought for in the writ petition. That's the most important thing. The relief sought for must have an impact on the cause of action. In the instant writ petition, if one looks at the relief's claim, it is an order of the government of Assam which is sought to be challenged. The impugned document is a letter at page 80 addressed by to the Deputy Commissioner Dhubri in Assam by the Director of Cultural Affairs, Guwahati. The subject of the said letter is development of house of late Pratima Bodua Pandey, Motiabag Palace in Gauripur, Dhubri, and for compensation for acquiring such building. Thus, the subject matter of the said document is a property in Gauripur, Dhubri, in Assam, and the beneficiaries of the letter are the private respondents number 8 to 13. That's my client, all residing outside jurisdiction of this honorable court. In the background of the aforesaid facts, the writ petitioners have failed to aver and to prove how the proceedings in partition suit in the Calcutta High Court are in any way connected with the relief sought for in the writ petition. The only pleading purporting to invoke the jurisdiction of this honorable court is in paragraph 26 at page 18 of the petition. It states only that, and I have quoted that, 1. Some of the records are lying in the High Court at Calcutta, original site, in connection with partition suit number so-and-so. 2. Some of the respondents are residing in Kolkata in West Bengal. 3. Some of the records are lying with the official respondents in Assam. And thus, and this is Malda I've quoted, thus some cause of action arose within the jurisdiction of this honorable High Court at Calcutta.
So who are
Unquote.
the respondents who are residing in Calcutta?
No, none. Respondent number 14 has been impleaded long after the writ petition was filed, who is stated to be residing within jurisdiction, but he has got nothing to do with this particular. Well, he has got no connection whatsoever with either the order which was passed or with Motiabag Palace. Paragraph 8. Respondents are outside, property is outside, the authority which has passed the order, they are outside. My learned friends' clients are outside. Well, I do not know how the existence of the record of a partition suit can, my lord, possibly give rise to a part of the cause of action so as to invoke the jurisdiction of this court. Para 8, it is submitted that petition does not contain any statement that any part of the cause of action has arisen within the jurisdiction of this court. It is not understood how the allegation that within court some records in connection with the partition suit number so and so lying in High Court at Calcutta can constitute cause of action in the writ petition, where the relief sought is cancellation of an acquisition of property in Assam by the government of Assam. The existence of such records will have no bearing on the order dated 10th October 2022 impugned in the instant writ petition. Then para 9, it is submitted that jurisdictional facts are required to be specifically pleaded in the writ petition in order to invoke the territorial jurisdiction of the court, and as authoritatively laid down in the case of Oil and Natural Gas Commission, which I just now cited before Lordship. I am going to, my lord, place this judgment before Lordship. Oil and Natural Gas Commission versus Utpal Kumar Basu, reported in 1994, 4th Supreme Court cases 711 para 6. The question of territorial jurisdiction must be decided on the facts pleaded in the petition. Secondly, the court is also to ascertain if such facts as pleaded are in any way connected with the relief sought for by the writ petition. It is submitted that the facts pleaded in the writ petition in the light of the above pronouncements of the court are not sufficient to establish that a part of the cause of action has arisen within the jurisdiction of this court, and that the same are in any event connected with the reliefs claimed in the petition. Furthermore, the allegation in the writ petition that some of the respondents are residing at Calcutta in West Bengal is an ex facie incorrect statement. This is a false statement. None of the respondents in the writ petition, as initially instituted, was admittedly resident of or located in West Bengal. The respondent number 14 has been brought on record long after, it should be long after the writ petition. My lord, kindly, I'm sorry, my lord, this is a mistake. Long after the writ petition was instituted, only by way of amendment as an afterthought. The said respondent has no connection whatsoever with the relief prayed for in the writ petition. Thus, neither any part of the cause of action arose within the jurisdiction of this court, nor any of the respondents in respect of whom relief has been sought in the writ petition is situated within the jurisdiction of this honorable court. Thus, I have summed up. To sum up, A, the parties to the proceedings, both the petitioners and the respondents, are in Assam outside jurisdiction of this honorable court. B, impugned order challenged in the writ petition is an order passed by an instrumentality of the government of Assam and to be implemented at Dhubri, Guwahati in Assam. C, the property which is affected by the impugned order is situated in Dhubri in Assam. D, there is no averment in the writ petition sufficient in law to establish that any part of the cause of action had arisen within the jurisdiction of this court. On this ground alone, without anything more, this writ petition is liable to be dismissed. My lord, I have summarized exactly the submission I have made. I have not, my lord, deviated from any of the submissions I have already made. My lord, now I have already cited the decision reported in 1985. This is my lord, para 13. The respondent rely upon the following decision in support of the submission. Well, I shall place this judgment, my lord, the relevant paragraph. Paragraph 14, my lord. This is to answer my learned friend again. It has been contended by the writ petitioner. I foresaw that this particular argument will be made. So, my lord, paragraph 14, my lord, I have given an answer. It has been contended by the writ petitioners that the respondents did not appear at the first hearing when the interim order was passed and took the point of jurisdiction before this court, and therefore the writ petitioners are precluded from raising.
Sorry to interrupt. Which judgment are you reading?
My lord, I'm sorry. I'm reading, my lord, para 14 of my note.
Oh.
Yeah. My lord, kindly come to para 14. I shall come to the judgments which I have referred to here afterward. This just to, my lord, answer exactly my learned friend's point. It has been contended by the writ petitioners that the respondents did not appear at the first hearing when the interim order was passed and took the point of jurisdiction before this court. And therefore, the writ petitioners are precluded from raising the question at this stage of hearing. I think this is what my learned friend submitted. It is submitted that this contention of the respondent is entirely misconceived. In the judgment reported in 1994, 4th Supreme Court cases 711, which I just now placed, a bench of 3 learned judges of the Supreme Court has held in para 14 that even if the writ petition is entertained by a court initially on the basis of the averments made in the writ petition, that a part of the cause of action had arisen within jurisdiction, it would still be open to the respondents to dispute the said averments. And if the respondents succeed in showing that the averments were not true and correct, the petition, though initially entertained, would fail for want of jurisdiction. This completely answers my learned friend's question. Now, my lord, kindly, I shall quickly go through these judgment decisions, my lord, which I have referred. I have already placed, my lord, Suaika Properties Judgment, 1985, 3 Supreme Court cases 217.
Yes.
My lord, kindly take this Oil and Natural Gas Commission's judgment,
The book?
1994, 4 Supreme Court cases. I shall just place, my lord, the relevant paragraph. আমার বইটা কোনটা? এটা না, এইটা
Yes.
আমার বই। আমার কাছেই কপি নেই। I can give you my book after help. In fact, I could not hand over a copy to my learned. এটা কপি করনি কেন এটা? I mean, this is the most important judgment.
Here. Both the books were here. You were reading from one and I give my note.
It's not a question of books. It is a copy of the judgment. You better get hold of a copy of the judgment. My lord, kindly come to para 4.
Yes.
The judgment of Mr. Ahmedip. At the hearing of this appeal, we indicated to the council that we would like to confine ourselves to the preliminary objection of ONGC that the High Court of Calcutta had no jurisdiction to entertain, hear, and dispose of the writ petition in the manner it did, as the averments in the writ petition, even if assumed to be correct, did not disclose that even a part of the cause of action for institution of the said writ petition had arisen within the jurisdiction of the Calcutta High Court. The writ petitioners averred in para 43 of the writ petition that a part of the cause of action had arisen within the jurisdiction of the High Court as pleaded in para 5, 7, 18, 22 and 26 of the writ petition. They further averred in the said paragraph that they were likely to suffer loss at its registered office within the jurisdiction. Well, in that case, the registered office of the petitioner was situated within jurisdiction. And so they pleaded that they would suffer loss in its registered office in Calcutta within the jurisdiction if the contract was not awarded to them. The averment in para 5, 7, 8, 22, then it has been quoted. Now, I'm not troubling your lordship with that. Then, my lord, kindly come to para 5. Clause 1 of Article 226 begins with the non-absente clause, notwithstanding anything in Article 32, and provides that every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases, any government within those territories. Can you note this? Any government within those territories, quote unquote, directions, orders, writs for the enforcement of any rights conferred by Part 3 or for any other purpose. Under Clause 2 of Article 220, the High Court may exercise its power conferred by Clause 1 if the cause of action wholly or in part had arisen within the territory over which it exercises jurisdiction, notwithstanding that the seat of the government or the authority or the residence of such person is not within those territories. On a plain reading of the aforesaid two clauses of Article 226 of the Constitution, it becomes clear that a High Court can exercise the power to issue directions, orders, or writs for the enforcement of any fundamental rights conferred by Part 3 of the Constitution or for any other purpose if the cause of action, wholly or in part, had arisen within the territories in relation to which it exercises jurisdiction, notwithstanding that the seat of the government or authority or the residence of the persons against whom the directions, orders, or writ is issued is not within the said jurisdiction. In order to confer jurisdiction on the High Court at Calcutta, NICO must show that at least a part of the cause of action had arisen within the territorial jurisdiction of this court. That is, at best, its case in the writ petition. Well, this was also again from Calcutta. Then, my lord, kindly come to cause of action. I am not troubling your lordship. Kindly come to para 10. My lord, various decisions have been cited. The facts have been of that particular case had been analyzed. Para 10. The submission of the learned counsel for NICO, that is, my lord, the writ petitioner, was that the clause 2 was introduced in article by 226 of the Constitution to enlarge the scope of the writ jurisdiction of the High Court. The Supreme Court in so and so has said this. Thus, then, my lord, after the quotation, thus this court ruled that in the absence of a specific provision in Article 226 of, on the lines of the, my lord, previously Article 226(2) was not there, only 226(1). So the seat of the government, my lord, that used to, my lord, form the, my lord, the jurisdiction which the court could have exercised. So if only 226(1) had been here, then automatically the matter would have gone to Assam, because, well, the government which is passing the order, impugned order, is the government of Assam. But now, my lord, 226(2) has been added. So, my lord, the scope has been widened. So if any part of the cause of action can be shown to have arisen within jurisdiction, then my learned friend client is then entitled to institute the proceedings here. Here, in this particular case, and this is what it says, in this particular case before your lordship, nothing has been shown to have arisen within jurisdiction. Only thing that has been mentioned is paragraph 26, which I have quoted before your lordship. And there, what they are saying is that the partition suit is pending in the Calcutta High Court in respect of all the properties, including this property. Therefore, it should, this court will have jurisdiction. See, my lord, how this court has, how the Supreme Court has dealt with it. My lord, this, the paragraph 11 is Suaika's case, 1985, Supreme Court, which I have placed before lordship. Very strongly, my lord, it was condemned for the Calcutta High Court to invoke the jurisdiction. I am not troubling your lordship with this. Para 12. Pointing out that after the issuance of the notification by the state government under Section 52(1) of the Act, the notified land became vested in the state government, free from all encumbrances, and hence it was not necessary for the respondent to plead the service of notice under Section 52(2) for the grant of appropriate direction or order under Article 226 for quashing the notification acquiring the land. This court therefore held that no part of the cause of action arose in the jurisdiction of the Calcutta High Court. This court deeply regretted and deprecated the practice prevalent in the High Court of exercising jurisdiction and passing interlocutory orders in matters where it lacked territorial jurisdiction. Notwithstanding the strong observations made by this court in the aforesaid decision and in the earlier decisions referred to therein, we are distressed that the High Court of Calcutta persists in exercising jurisdiction even in cases where no part of the cause of action arose within its territorial jurisdiction. It is indeed a great pity that one of the premier high courts of the country should appear to have developed a tendency to assume jurisdiction on the sole ground that the petitioner before it resides in or carries on business from a registered office in the state of West Bengal. In our case, even that is not there. We feel all the more pain that notwithstanding the observation of this court made time and again, some of the learned judges continue to betray the tendency. Only recently, while disposing of an appeal arising in SLP number so-and-so, Aligarh Muslim University, this court observed, we are surprised not a little that the High Court of Calcutta should have exercised jurisdiction in a case where it had absolutely no jurisdiction. In that case, the contract in question was executed at Aligarh. The construction work was being carried out at Aligarh. The contracts provided that in the event of dispute, the Aligarh court alone will have jurisdiction. The arbitrator was appointed at Aligarh and was to function at Aligarh. And yet, merely because the respondent was a Calcutta-based firm, it instituted proceedings in the Calcutta High Court. And the High Court exercised jurisdiction where it had none whatsoever. It must be remembered that the image and prestige of the court depends upon how the members of that institution conduct themselves. If an impression gains ground that even in cases which falls outside the territorial jurisdiction of that court, certain members of the court would be willing to exercise jurisdiction on the plea that some event, however trivial and unconnected with the cause of action, had occurred within the jurisdiction of the said court, litigants would seek to abuse the process by carrying the cause before such members, giving rise to avoidable suspicion. That would lower the dignity of the institution and put entire system to ridicule. We are greatly pained to say so, but if we do not strongly deprecate the growing tendency, we are afraid, be failing in our duty to the institution and the system of administration of justice. We hope that we will not have any other occasion to deal with such a situation. Then, my lord, the submission, I am not, paragraph 13, I am not troubling. Paragraph 14, well, this is the paragraph which I just now placed before your lordship, which says that even if originally the jurisdiction point was not taken, if ultimately after looking into the facts and circumstances of the case, the court comes to the finding that no part of the cause of action has arisen within jurisdiction, the court that should not, my lord, in any way dissuade the court from, my lord, dismissing the writ petition on the ground that it had no jurisdiction. No. My lord, this is what it says. Before we part, we must clarify that we have confined ourselves to deciding whether on the averments made in the petition, any part of the cause of action is shown to have arisen within the jurisdiction of the Calcutta High Court. Even if we had come to the conclusion that the averments disclosed that a part of the cause of action had arisen within jurisdiction of the said court, and therefore the petition would be entertained by that court, it would still have been open for the opposite party to dispute the said averment, and if the opposite party were to succeed in showing that the averments were not true and correct, the petition, though entertained, would fail for want of jurisdiction. So, at the final hearing, the court can decide that you don't have any jurisdiction to do so. And in this particular case, this is exactly what happened. Supreme Court, final hearing, the court said that it had no jurisdiction, even though the Calcutta High Court held that it had. My lord, the next judgment that I would like to place, only a few paragraphs, is, my lord, reported in 2002, one Supreme Court cases, page 567. I shall, if I have a copy, my lord, I shall give copy to my lord. (2002), one Supreme Court case. The only copy to run. Well, may I? 2002, 567. 2002. 567. এটা কি 2002? দেখে আমাকে দাও। My lord, kindly take straight away, come to paragraph. This is, my lord, Union of India versus Adani Exports. Paragraph 12. Oh, the copy নেই, একটা কপি দাও না জজ এই ওদের একটা কপি, ওদের কপি দিয়েছো না দাওনি তো বলছিস, নো কপি এন্ড নো কপি এন্ড মানে para 12.
Yes.
This is again, kindly see the what has to be pleaded. On the basis of the pleading, the assumption of jurisdiction takes place. We will now examine whether any of the facts mentioned in para 16 of the application, or for that matter, in the entire special civil applications, would give rise to any part of the cause of action at Ahmedabad, at least for the purpose of conferring territorial jurisdiction on the High Court at Ahmedabad. At this stage, it is relevant to mention that it is an admitted fact that none of the respondents in the civil application are stationed in Ahmedabad, the same is our case. It is also an admitted fact that the passbook in question, benefit of which the respondent is seeking in the civil application, is issued by an authority also stationed in Chennai. Our case, my lord, situated in Assam. The designated authority who is competent person in respect of the matters concerning the passbook scheme and who discharges various functions under the scheme is also stationed in Chennai. Exactly the same as in our case, also situated in Assam. The entries in the passbook under the scheme concerned are to be made by the authorities at Chennai. Same here, my lord, in Assam. The export of prawns made by the respondents and the import of the inputs, benefit of which the respondents are seeking in the application, also will have to be made through the same port in Chennai. In spite of the above admitted facts, the respondents herein plead that as per the plea raised by them in para 16 of the special leave petition, special civil application, the following facts give rise to the cause of action conferring territorial jurisdiction on the court at Ahmedabad. They are: one, the respondent carry on business of export and import from Ahmedabad. In our case, my lord, it does not say so. Their orders of export and import are placed from and are executed in Ahmedabad. This was pleaded. The court said this is not a part of the cause of action. Three, documents and payments for export and import are made at Ahmedabad. Assuming, my lord, that the partition suit is pending here, this was also the documents and payments for export and import are sent and made at Ahmedabad. This was, my lord, pleaded. The credit of duty claimed in respect of the exports are handled from Ahmedabad, since export orders are received at Ahmedabad and payments also received at Ahmedabad. 5. Non-granting and denial of utilization of credit in the passbook will affect the business of the respondent at Ahmedabad. The respondents have executed bank guarantee through their bankers at Ahmedabad, as well as the bond at Ahmedabad. All these were pleaded. But notwithstanding that, the Supreme Court said that nothing has happened in the jurisdiction. In our case, my lord, these facts were even not there. Though it is also contended in para 16 of the application that the appellants have their office at Ahmedabad, that contention has not been pressed, since it is clear from the records that none of the appellants have their office at Ahmedabad. Divorce this fact, if we take into consideration the other facts enumerated herein above in support of the cause of action pleaded by the respondent, it is seen that none of these facts is in any way connected with the relief sought. My lord, kindly note this word. None of these facts in any way connected with the relief sought for by the respondent in their civil application so as to constitute the cause of action at Ahmedabad. So, my lord, this is the important fact. First of all, you will have to plead and show. Everything depends upon your pleading. It is not a case of, my lord, that you come into the court and produce evidence. No. The court will proceed on the basis of your pleading. If you do not plead that any part of the cause of action has arisen within jurisdiction, then you are out. You cannot invoke the jurisdiction of this court. Firstly. Secondly is that the facts which you plead must have connection with the relief sought. Here, what is the relief sought? A letter is sought to be cancelled. That is all the relief that has been sought in the petition. So how it is, my lord, it will constitute cause of action, my lord, it is unknown to me. My lord, this is para 12. Para 16, my lord, Oil and Natural Gas Commission, Utpal Kumar Basu, which I just now cited, that has been quoted in extenso. And then para 17, this is the last paragraph I placed in this judgment. After quoting that, which I placed before Lordship, it is seen from the above that in order to confer jurisdiction on a High Court to entertain a writ petition or a special civil application, as in this case, the High Court must be satisfied from the entire facts pleaded in support of the cause of action that those facts do constitute a cause of action so as to empower the court to decide a dispute which has, at least in part, arisen within its jurisdiction. It is clear from the above judgment that each and every fact pleaded, my lord, kindly note the words pleaded, by the respondent in their application does not ipso facto lead to the conclusion that those facts give rise to the cause of action within the court's territorial jurisdiction, unless those facts pleaded, are such which have a nexus or relevance with the list that is involved in the case. Facts which have no bearing with the list or the dispute involved in the case do not give rise to a cause of action so as to confer territorial jurisdiction on the court concerned. If we apply this principle, then we see that none of the facts pleaded in para 16 of the petition, in our opinion, falls into the category of the bundle of facts which would constitute a cause of action giving rise to a dispute which would confer territorial jurisdiction on the courts at Ahmedabad. So, my lord, I am also very strongly relying upon this judgment. My lord, the next one, the two other short judgments, my lord. One is Kushum Ingots versus the Union of India, 2004, 6 Supreme Court cases, 254. Copy দিয়েছো? Again, just a copy now.
So this is from SCR, so I just written the paragraph numbers presided by pen. You also be kindly excused by photocopy. The paragraph numbers are in pen.
Yes.
Well, I'll kindly take first paragraph 2, just to have the facts. Para 2. Does it start with the word the appellant is a company?
Yes.
The appellant is a company registered under the Indian Companies Act. Copy the
Yes.
The appellant is a company registered under the Indian Companies Act. Its registered office is at Mumbai. It obtained a loan from Bhopal branch of the State Bank of India. Respondent number 2. Respondent number 2 issued a notice for repayment of the loan from Bhopal purported to be in terms of the provisions of the Securitization and Reconstruction of Financial Assets and Enforcement of Securities Interest Act 2002. Questioning the virus of the act, the said writ petition was filed before the Delhi High Court by the appellant herein, which was dismissed on the ground of lack of territorial jurisdiction. Then, my lord, I am not troubling your lordship, the submissions which have been made. Kindly come straight to para 12. Para 12, my lord, is again quoting from Oil and Natural. That is the leading judgment, Sri Judge's bench. This court in Oil and Natural Commission held that the question as to whether the court has territorial jurisdiction to entertain a writ petition must be arrived at on the basis of averments made in the petition, and the truth or otherwise thereof being immaterial. So there must be averments. Then, my lord, para 13, quoting from that, I'm not troubling your lordship. Para 14 is quoting from Swaika Properties, 1985, which I had cited before, lordship. Then para 15, Aligarh Muslim University, which has been quoted in, my lord, in the earlier judgment of Oil and Natural Gas Commission. Then para 16, Union of India versus Adani Exports. Para 16, if I may just place before lordship, the Union of India and Adani Exports, it was held that in order to confer jurisdiction on a high court to entertain writ petition, it must disclose that the integral facts pleaded in support of the cause of action do constitute a cause so as to empower the court to decide the dispute, and the entire part of it arose within its jurisdiction. Recently, National Textile Corporation versus Haribak Savalram, which is, my lord, I am going to cite before lordship. This is, my lord, earlier judgment, but reported subsequently. As discussed earlier, the mere fact that the writ petitioner carries on business at Calcutta, or that the reply to the correspondence made by it was received in Calcutta, is not an integral part of the cause of action. And therefore, the Calcutta High Court had no jurisdiction to entertain the writ petition, and the view to the contrary taken by the division bench cannot be sustained. In view of the above finding, the writ petition is liable to be dismissed. 18. The facts pleaded in the writ petition must have a nexus on the basis whereof their prayer can be granted. This is, my lord, the ratio of the judgment. The facts pleaded in the writ petition must have a nexus on the basis whereof a prayer can be granted. Those facts which have nothing to do with the prayer made therein cannot be said to give rise to a cause of action which would confer jurisdiction on the court. So, my lord, this is another judgment. And the last one is, my lord, National Textile Corporation, Haribak Savalram. That also unfortunately went from Calcutta. This is reported in 2004, 9 Supreme Court cases, 786. Well, this is.
You have a copy? No.
I think this one has not been done.
তোমরা আমার সঙ্গে যদি একটু আগে বসো তাহলে you know exactly what I'm going to do. Well, this is reported in 2004, 9 Supreme Court cases, page 786.
Yes.
The copy, sorry, I can't give you because even for the learned judge, I have blown to be copy. So I shall give you my book.
No.
786. Well, may I just hand up to your lordship this? Para 10 to 12, I'm not troubling your lordship. Well, this is again went from Calcutta. Well, what happened in this case was, in the very first paragraph that shows, the single bench dismissed the writ petition because it had no jurisdiction. Division bench reversed the decision and said, we have jurisdiction, and entertained it. Matter went to the Supreme Court. The Supreme Court reversed the decision of the division bench and restored the judgment of the trial court. My lord, here, only I just want to place before Lordship para 10 to 12. I shall hand up to your Lordship. Para 10 to 12. I'm sorry, my lord, I don't have a copy. A copy টা আজকেই করে দেবে.
My apologies.
Yes, the same ratio has been laid down in this also.
Lordships. And this has been quoted in, my lord, the judgment, earlier judgment I placed before Lordship. So, my lord, these are my respectful submissions on the jurisdiction point.
They are all based on Oil and Natural Gas Commission. That's the parent judgment.
Yes. That is the parent judgment. So, my lord, my respectful submission is this: nothing has been shown to your Lordship that if any part of the cause of action arose within jurisdiction. No, but to be fair to my learned friend, I must show to your Lordship what they have pleaded. Kindly come to take the writ petition. Kindly take the writ petition, paragraph 7 and 8. Unfortunately, they have not pleaded this in the paragraph 26. They have not, no reference of this in para 26. Para 20, Lord, it's the averment. I am giving, my lord, my learned friend clients the benefit of doubt, giving them the long rope as much as it is possible. Even though para 26 does not say, my lord, as to which part of the cause of action arose within jurisdiction, I am, my lord, granting them this. Page 6, para 7. That the petitioner state that the said special referee and commissioner partition, Pratul Chandra Datta, who was appointed, my lord, in the partition suit, having been appointed by the court, High Court, by order dated 1963, proceeded to do acts and things mentioned in clause 31 of the terms of settlement or the solemnama mentioned above, and had surveyed the suit properties and submitted his detailed report dated 28/5/1977. Kindly note this, my lord. Para 6 is saying that the commissioner of partition was appointed, and by consent of all the parties, including my learned friend's predecessor in interest, a preliminary decree was passed on 20th August 1963. That is at page 6, paragraph 6. Then paragraph 7 says that in terms of that preliminary decree, Pratul Chandra Datta was appointed the commissioner of partition, and he filed his detailed report on 28/5/1977 before the High Court for acceptance, wherefrom it appears that the properties specified in clause 31 of the said terms of settlement. My lord, kindly take page 46. This is the terms of settlement. I don't know whether your lordship will be able to read it, because the copy I have been served with, my lord, I have been given. It's very difficult to read. Kindly, my lord, come to page 46.
Yes,
Keeping this open, clause 31. Clause 31 is at page 46.
yes.
This is the preliminary decree. Can you lordship read what is written?
It's quite legible, yes.
Okay. Then, my lord, as commissioner of partition, special Sri P.C. Datta solicitor will do the following acts. Then, my lord, subject to the provision of these terms of settlement, and in particular to the provisions of paragraph 28 and 34 hereof, he will make and effect complete partition. My lord, kindly note this, of the estate of Raja Prabhat Chandra Badua and Kumar Promothesh Chandra Badua amongst the residuary legatees under the will and codicil of the said Raja Prabhat Chandra Borua and Kumar Promethesh Chandra Borua in accordance with their respective shares under under the will of Raja Prabhat Chandra Borua and so and the will of Promethesh Borua. Now, my lord, so this is the clause that has been referred to at page 6 in paragraph 7. It says that before the High Court for acceptance, wherefrom it appears that the property specified in clause 31 of the said terms of settlement, then II 24I, Palace of Matiabag, with compound comprising an area of 75 bighas or thereabout, as may be ascertained by the special reference, item number 1 and 1/3 share of the property mentioned in para so and so, share of Kumar Promethesh Chandra Borua and 1/3 property of Kumar Promethesh Chandra Borua of clause so and so, Assam, were allotted to Alokesh Chandra Borua, Shamulesh Chandra Borua and Arup Kumar Borua. As legality of the Kumar Promethesh Chandra, as it should be legal heirs of Kumar Promethesh Chandra Borua. The petitioners being daughters of Arup Kumar Borua, now deceased, had acquired right, title and interest upon the said property. That the fact would be evident from number 147 filed on so and so with all annexures dated so and one appeal filed in so and so in view of the preliminary decree passed on 28/8/63 on the basis of said terms of settlement. The respondent number 8, 9, 10, 11, 12 and 13 of this petition who were added as the defendant number so and so cannot claim any this is the point, cannot claim any exclusive right, title or interest in or upon the property of Palace Hawa Mahal at Matiabag with the compound comprising, it's not compromising, comprising an area of 75 bighas or thereabout, as may be ascertained by the special reference. In other words, respondent number 8, 9, 11 and 12 and 13 of this writ petition have no right to sell, transfer or mortgage any portion. This is, my lord, the cause of action. This has been stated in this particular paragraph. Now, first of all, I say that it does not constitute a part of the cause of action, which is the cause of action in the writ petition. This may be a cause of action in the partition suit. One is entitled to go over there, make their raise their voice and claim share in this partition. But be that as it may, they say that 8, 9, that's my client, 8, 9, 10, 11, 12 and 13 have no exclusive right in respect of this property. My lord, my submission is this, that totally has been suppressed the subsequent events, which have come out in the affidavit of the state of Assam, because they were placed before it. And unfortunately, my lord, the writ petition is totally silent of this. I will submit to your lordship that on the ground of suppression of these very material facts, which I am going to place before your lordship now, this application is again, the second point, the application is liable to be dismissed. Even if your lordship entertains the application, it should be dismissed on the ground of suppression of material facts. What are the suppressions? I am now telling your lordship. Can you give me 1 second? Can you give me 1 second? My lord, for your lordship's convenience, my lord, I have also prepared a short note on this. Your lordship can treat these notes of argument as it will be easier for your lordship to know, treat it as an index. And this, my lord, contains, my lord, all the page numbers of all these, my lord, affidavits, which I am going to cite before your lordship. My lord, may I hand up to your lordship? If there are some typographical errors,
Why don't you please confine your argument to the jurisdiction issue only for the moment and not go into merits?
Very well. If
Let
your
this be
lordship,
decided first.
very well. If your lordship, then my learned friend can answer, then my lord, I can the suppression of material fact is so much that this entire thing, assuming everything to be right, my lord, this writ petition is liable to be dismissed because what happened after the compromise decree, after the preliminary report, nothing has been said. Only a lot of what
That strikes at the merit.
yes.
So let us decide the
Merit in the
jurisdiction
sense, my
issue.
lord, suppression of material facts is one of the preliminary issues I am taking before your lordship. But if your lordship wants to hear the jurisdiction issue first, well, let them argue and then I shall come back.
The state of Assam, do you have to add anything to this?
I've already placed on record on the audit.
No, on the jurisdiction issue, you want to place anything else? Nothing. So I can hear the petition. No, I think I'll hear the petitioners on the next occasion because it's 12:30 already. Then when can you come back? You're supporting, right?
We would not be one, because since they submitted written
We
agreement.
will deal with
Give
the
the
jurisdiction
note of the reply.
Yes,
because Mr. Mitra is concluded with this jurisdiction issue. We will like to reply on the jurisdiction issue.
right.
When we proceed on the suppression, point wise we will proceed.
When can you come back?
But the matter will be fixed tomorrow also.
What is another schedule that?
So tomorrow we'll continue 11:30 tomorrow.
Yes, tomorrow.
So we can at least complete this issue.
Yes, madam, very well. I abide by whatever you
Certain, then my lord.
Right.
If it is rejected on the ground, I have no.
Right. Third Learned Council for respondent numbers 8 to 13. Paragraph, let the matter appear under the same heading, conflict dating on the 7th, marked at 11:30 a.m. Tomorrow 11:30.
It's already fixed.
It's already fixed.
And I shall hand over the photocopy of the judgment.
Please. In course of this day, if possible,
By lunchtime, I will hand it over to your court officer.
you can take back the books. দুটো বই আছে ফেরত দিন।
এগুলো বাঁধে ওই আসলে
এটার order আলাদা হবে, না কিছু করার নেই। এই বইটা ফেরত দিন। যে এবং সব।
And my lord, I have also dealt with the judgment cited by them. I say it has no application. It is not an Article 210 at all.
May I take the book back?
Yes, দুটো বই ফেরত দিন।
এগুলো কপি দিয়ে দাও।
Pension.
Item number 9 to 12.
Pension matters, 625.
Item number 8 to 12, maybe take it not this week. I am not feeling well.
It has not been called, sir. I cannot give dates like that. Please come back, let me see.
Well, I will not come because I am not feeling well.
I am for the statement. I am on behalf of the petitioner. I am for the state response. My agreement of service. Lordship, this matter is related to here.
Give me. There's so much of noise. Sir.
Stop. The Lordship, this matter is related to the ECL. Acquire my plot of land. No one?
Anyone appearing for the ECL?
No, Your Lordship. Your Lordship, by notification.
Have you served the ECL?
Yes, Your Lordship.
Mr. Day, you're appearing for the state?
Your Lordship, kindly come to the page P9.
Page?
Page 111, Your Lordship. By a notification, Your Lordship, ECL says we acquire your land. অধিগ্রহণ করা হইবে।
করা হইবে।
করা হইবে। Your Lordship, on that notification, the petitioner will contact the ECL headquarters, and the ECL directed the petitioner to contact with Mr. Piyush Kanti Das, the next page, Your Lordship, 112, the learned advocate who representing the ECL on that time, and verify the petitioner's original document, Your Honor. And after that, the learned advocate advised your petitioner to make an affidavit and indemnity bond to the agent of Bonjimari Colliery of ECL. So the petitioner do the same. The Lordship, kindly come to Annexure P11 series, page 117.
Yes.
Your Lordship, now the problem is the land was not acquired. And after this notification, when petitioner make RTI,
The ECL wanted to purchase, not acquire.
purchase, yes, Your Lordship, but no compensation was given. No compensation was given, and if Your Lordship come once,
It has been taken over by the ECL. Possession has been taken over
No,
by
no,
the
no,
ECL. No.
no. Your Lordship.
What is your prayer?
Your Lordship, Anandobala Dashi, the ECL says that the Anandobala Dashi, the previous owner to whom I have purchased, the petitioner was purchased, they are the Jobor Dakhuldar, Your Lordship. Then, Your Lordship, my position or my right to the over the plot of land is gone. Your Lordship, I have only prayer.
So you have to apply for correction of the records.
Your Lordship,
You have to apply for correction of records. Have you done that?
no, Your Lordship, I have not done. Your Lordship,
To correct the records, isn't it?
yes, Your Lordship. But Your Lordship, after I have purchased, my name was recorded in the RS records.
That is as Jabur Dakhulkar, you say.
Jobor Dakholkar, when I have made an RTI before the Land and Land Reforms Department, they says that the previous owner whom I have purchased are the Jobor Dakholdar in their land. I mean the ECL's land. So Your Lordship, I have only prayed for please ECL come before this court and says that make it clear whether they have purchased the land from the previous owner or any was made in this behalf or anything was made.
ECL is not present before this court. Yes,
ECL
Mr.
is-
Dey? One part is correction that cannot be considered.
Yes,
That cannot be
that
considered by this
cannot
court.
be
Yes.
considered, Your Lordship.
That will be considered by the seal. We never find any application as seen so far. Your prayer is nothing, my lord. What if my lord submitted to your lordship, that was not reflected in the petition. That is a very,
Your Lordship,
but if you want to get any.
You are asking for case acquisition case number. There is no acquisition at all.
no, Your
Then?
Lordship.
Why are you asking for acquisition? Your prayers are not very correct. Why are you asking for acquisition case number? There is no acquisition.
Acquisition case, my prayers.
Lawyer advocate's letter says the ECL can purchase.
ECL.
Purchase is not acquisition.
No.
Then your prayers are not very sound.
Yes.
Not the effect of the recording of the. That is not.
কি বললো? Yes.
That here is not my. Correction of.
Look,
record.
see that?
Syllabus is not a school.
পড়েছি তো।
School, that all. It's not everything.
They have already acquired my land. এই application টা কোথায়? Main grievance against the my lord Colliery. They have already, your lordship kindly come to page 13.
Page?
Page 13 that, my lord, reply,
125.
page 125, P13. In reply, my lord, to RTI, they have stated, my lord, your lordship, page 125,
Yes,
P13.
yes.
To my client, reply to apply RTS. This has to your application RTS such and such. The same was forwarded to the area land dealing officer, Salanpur area. The reply, the department of such and such dated author has been received by this office, which is enclosed here is for your kind information. Kindly come to next page, my lord. Next page, 126.
Yes.
This is a letter dated 13/12/2022. My lord, your application such and such approved to the letter mentioned above as per application RTI dated 22nd November 2022 as submitted by Gautam Korai such and such, in which the information sought in plot number 463/6/11 under Bandiari Mouja, jail number such and such, inherited land of ECL has been vested in the central government by application Coal Mine Sanitation Act. So they have acquired my land under the Coal Mine Sanitation Act, but no remuneration has been paid. They have already acquired.
What is your prayer? Have you prayed for
My-
compensation in the prayers?
My lord, your lordship can always amend the prayer.
No,
Well,
no, can't.
I got,
It is a different prayer altogether. It can be amended if it is related, if it is connected. It is not connected at all. Please, your prayers, you're asking for correction of the records and not to give effect to the recording of Jabod Dakulkar, which has no nexus whatsoever with compensation or acquisition.
my lord, What?
You have to withdraw and file afresh. I'll grant you liberty.
and prayer, my lord, but your lordship has to, I show you the judgment that there is your lordship can amend the prayer. I will show I will show you the lordship. Then my lord, liberty to withdraw file afresh.
And you have asked for case number, date of acquisition, payment, all this.
My lord,
Eight-
that prayer to full prayer.
You have not claimed compensation
My
at
lord.
all.
My lord, the prayer, my lord, there is
But your primary prayer is compensation.
Compensation, my lord, and date of payment of compensation on the basis of application of the petition.
compensation is also there.
My lord,
Do not-
prayer is-
Please do not repeat for a third time.
My lord,
I've heard it from your junior friend,
my lord,
then learned counsel, and
My
you
lord,
are the third person
my lord,
on the same ground.
my lord, your lordship kindly page to you. আমি দেখেছি তুমি। My lord, also there is prayer, the date of payment of compensation on the
Which is
basis.
payment of compensation. Have you claimed compensation?
Yes, my lord.
You say you have not paid it. You have the date of payment indicates you have been paid. Compensation has been paid. You are asking for the date only.
No,
But
my lord.
In principle, you are claiming
Payment of
compensation.
compensation on the basis of the application of petition. My lord,
Don't you
that
think you
is,
have to file a fresh writ petition, sir. I'll grant you liberty.
that no, my lord. My lord,
This prayer,
on-
it need not be there at all.
that is my lord, prayer is something I do agree. But my lord, this is, then you lordship get liberty to file a press. My lord, liberty to file a press. My lord, liberty to file a press.
Contrary to your submissions.
why they thought that your lordship can mold the reliefs on the basis of the facts. Simply,
I have to mold the entire writ petition.
no, on mold the relief on the basis of the right to information act. We had sought for the acquisition proceedings details.
Molded if it has any connection, any nexus. This has no connection at all with what you're saying.
That I have a doubt on. Only
Isn't
thing
it?
was, only thing is that we purchased the property. Thereafter, the acquisition notice was given. It is said in the acquisition notice that it will be made, and thereafter, just in a short order,
It said that it intimated the land has been vested in 73.
They say it is Jabbar, yes, it is.
73, it's 73.
EPL's
But
property
who are
vested.
the, and who are the, who has, there is in the act itself, your lordship has seen, there's a commissioner of compensation.
You have to frame your writ petition in a different manner
Prayer,
altogether.
prayer is defective, I bow
Not
down.
only prayer, you have to frame the contents also in a different manner.
That is, that aberrant is there, subject to question. That aberrant is
I'll
there
grant you
in the prayer page 10, that aberrant is there.
I
That
will
was.
grant you liberty.
Madam,
Affidavit of
self-conservation.
none appears for the Eastern Coalfields Limited despite service.
They are the main respondents.
Yes.
They are the main
Yes,
respondents.
No, I've recorded service.
Yes.
The petitioner seeks to withdraw the writ petition on account of certain defects detected therein and seeks liberty to file a fresh writ petition on the same cause of action.
Right.
Paragraph, in view of the above, the writ petition being WP such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to file a fresh writ petition on the same cause of action.
Obliged, madam.
However, in order as to costs, urgent certified writ.
Obliged.
Next.
My lord, the matter has come up at my instance.
Have you served?
My lord, at the time of mentioning, I have served the learned advocates for the state. My lord, the matter earlier appeared for consideration on 16 June. None appeared for the state or any other. So my lord has been pleased to post it on 6th of July. But then also, since no one is there, this time I have served upon the learned advocates by speed post. The matter is related to illegal utilization of my property by the state authorities, my lord, without issuing any notice for acquiring the property.
So they may I request you to appear to serve. Please serve a copy of the
My
writ
lord,
petition.
I shall. Both sides.
Yes, what is the matter about?
Yes, my lord. My land is being illegally utilized by the state authorities for construction of a bridge or flyover at the place, Kollani. My lord, my land is being utilized without serving any notice of acquiring the property, without granting any compensation. Nothing has been done, my lord. My lord can see now, I have made several requests under RTI Act to get information for the property. Why or how this is being done. Several requests under RTI, and thereafter certain replies were also made, whereby I was informed that my application is being transferred from this office to that office. My lord, there are some communications. Thereafter, my lord, on 20th February 2023, I made an application.
Demand of justice.
Yes, my lord. Demand justice, my lord. Demand justice I made because, my lord, in the meantime, I can do that, my lord, but there is no other paper, my lord. This is only the thing.
Will you do that?
My lord, I can do that, my lord.
1 month, within 1 month. Let it be.
I'm grateful, my lord.
Affidavit, none appears for the affidavit of service বড় দরকার নেই, আগে আছে ওটা ভাই।
Affidavit of service was filed on the last
Already,
occasion, my lord.
None appears for the state respondents despite service. Mr. Dev, who is present in court, regularized quorum, copy service direction. Paragraph. It is submitted on behalf of the petitioners that the land of the petitioners has been utilized by the state authorities without acquiring the same by due process of law or granting compensation to the petitioners in lieu thereof. The petitioners seek to several communications made by the petitioners with the authority in this regard yielded no fruitful result. The petitioners seek to submit a comprehensive representation before the concerned authority, ventilating their grievance, and pray for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the respondents submits that the special land acquisition officer,
And utilized by the West Bengal. Along West Bengal Highway Development Corporation, utilized. Mala, he is considered, if he utilized Mala, then
chairman.
yes, fourth Mala, that is the.
My lord, at present,
Fourth is the special land acquisition officer.
at present, the
Chairman West Bengal.
present,
That's the fifth respondent.
yeah, check.
Special land-
এখন construction চলছে।
Special land is the respondent.
Fourth, that the fourth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the decision is
One line. In next line, my lord, with the help of the respondent number 5, that will be, because my lord, that was not my lord, acquisition by us, my lord.
then the chairman will, yes, yes.
তা দুজনকে
Disposed of with liberty to the petitioners to submit a comprehensive representation before the fourth respondent within 2 weeks.
1 week, my lord.
Within 1 week from date. Stop, the fourth respondent is directed to consider and dispose of the representation within 1 month from the date of receipt thereof,
My lord.
upon affording reasonable opportunity of hearing to all concerned, including the petitioners, comma, in accordance with law. Paragraph, in dealing with the representation, comma, the fourth respondent is at liberty to take the assistance of the fifth respondent, comma, if required. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof.
I'm
Disposed
grateful.
of, which gentleman? Next.
Good, I'm for the petition.
Yes.
So there's a allegation of illegal construction, my lord, by the private.
Serve the private.
Served, my lord, received, they have received.
Where is the track report?
My lord, there's the, my
The
lord.
private respondent.
Delivered to address, my lord, this.
Murali is 467. Where is
My lord, may I find it?
it? At the interview? 467 is the postal receipt number.
My lord. So this is 467, my lord. Item on hold, door locked, intimation served.
Not service. Please serve and come back.
My lord, may I, my lord, humbly say, my lord, intimation served, my lord, is,
Intimation service service.
my lord, not affected, but my lord,
My lord, intimation,
Yes.
after intimation,
Door locked. Door locked. How is the intimation served?
normally the post box is there. My lord, normally, my lord, I'll serve again, my lord. My lord, I'll try again. I'll try again, my lord.
Please
There
do
should not be, my lord, no
mention
room.
Till the service is over. It will go back to the motion stage now.
That's the difficulty, my lord.
Please show me. What is it? It's illegal, unauthorized construction.
Unauthorized construction, my lord, on the PWD, my lord, have made a representation. They have to now consider, my lord.
Let me see the service. This is 671. This is not 467.
My lord,
The track
467, my
report
lord.
is not there at all.
No, my lord,
That's
the
what even I found. The number is
PWD ka code.
4671. Okay, 4671. Oh.
Not 467 IN.
Let it be accepted. Let there be a-
That is not an answer. After that, 7, 9.
So 9 টা বোধহয় হ্যাঁ 9 my lord Mr. Dey is represent.
7 also block land and land reforms officer.
My lord 8.
Only 8.
8 is the
I'll
private.
accept this
Only
service. I'll accept this
grateful,
service.
grateful. And my only prayer to be my lord kindly comes to page number 50 my lord. There's a representation made to the assistant engineer my lord.
PWD road.
PWD road.
So then let it be considered.
It was my lord delivered on
Affidavit of service.
4th.
None appears for the private respondent despite service.
না না আমি ওই
Paragraph.
চিঠিটা কবে deliver?
The petitioner claims to be the recorded owner of the plot in question and complains that the private respondent has raised unauthorized construction by encroaching upon a portion of PWD road adjoining his plot, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation in this regard to the concerned authority on, what is the date?
My lord, this is 4th of April 23. My lord, the
4th of-
bottom 4th April my lord. My lord, in Bengali it's written 4/4/23.
On 4th April 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the state respondents submits that the 4th respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition, the petition is disposed of, directing the 4th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, in accordance with law. Disposed of the chapter.
Grateful.
Next.
I'm for the petitioner, Your Lordship.
Lordships, in this matter, Mr. Santu Kumar Mutra appear on behalf of the state respondent. He is against call number 15, my lord. Kindly praying for not to deny.
Not today is not possible.
Your Lordship, this is an application for consideration of the representation. Your Lordship, the private respondent are constructing illegal construction upon the PWD in the front of my land, which is causing the disturbance in my ingress and egress. Your Lordship.
Have you served the private respondent?
Yes, everyone is served, Your Lordship, but the track
Where is your
report is not available, Your Lordship.
Then I cannot help you, sir. Why are you not ready? It's a mentioned matter.
Your Lordship, I've checked the server, but it's saying consignment details not found. That is the problem. I've served on everyone, Your Lordship.
Please do not mention before the affidavit is ready, isn't it? It goes back to the motion. You lose a day.
Yes, Your Lordship, but Your Lordship, I've served the
Since service upon the private respondents is not complete, let the matter appear under the heading motion on 15th March. Next.
I am for the petition. An allegation of unauthorized construction over public land, or service affected. But initially that came as not sub, so 1 second, now it's. So, my lord, I am filing 2 affidavits of service.
Why didn't you file the served one?
No, both. The first one that shows service, my lord, the thin one that shows service upon the private respondent. And the thick one is not, my lord. And this has been effective.
So there you're appearing.
Page 23, that's earlier order, because well, initially police inaction that was moved, that was wrongly moved, so well, liberty was granted to approach the appropriate authority and take steps. Accordingly, page 24.
PWD land or government land?
Government land.
62 Act.
62 Act, my lord, the representation before the district magistrate.
SDO. Page 24. Affidavit of service. None appears for the private respondent despite service. Paragraph. The petitioners claim to be the recorded owners of the plot in question and submit that the private respondent has raised unauthorized construction by encroaching upon a portion of government land adjoining their plot, thereby obstructing their egress and ingress. So the petitioners submitted a representation in this regard for the concerned authority on under the West Bengal Public Land within bracket eviction of unauthorized occupants bracket closed Act, 1962 on 1st May 2023, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Representation. A paragraph. Learned counsel for the state respondents submits that the fifth respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the fifth respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondent, in accordance with law. Disposed of.
Good, ma'am.
Next.
May please, Your Worship. Madam, I am applying for the Haldia municipality, madam. My lord, what happened? My lord, a piece of land was given.
State is not there, not required. It's appealing for
The state has got no role here because the Haldia is the real authority.
But you have implemented all the state.
Yes, yes. They have received. madam.
So they have no role.
Yes, we have stopped, but they have received. Now, kindly, madam, look at page 46.
Give me a minute before that, sir. State has been served.
Yes.
May I request one of you? Please serve a copy to Mr. Bandhu.
দেওয়া হয়েছে তো আমার একটা কপি সে দিয়ে দিবে সে দিয়ে এক্ষুনি দিয়ে দিচ্ছি
Yes, what is the matter?
My lord, kindly look at page 46. My lord, we are entitled to get a certain land. We have given. My lord, but son has betrayed the others. And my lord, we made one son has betrayed mother and others, other brothers and sisters. Page 46, my lord, we filed a representation. My lord, Mr. Justice Mausami Bhattacharya was pleased to direct the authority, hold the authority to consider the same and decide. It has been done. Next page, page 48. In WP matter of Amina Bibi Satansaj, the order High Court, Calcutta respondent for chairman was directed to consider the representation of the petitioner of 11 November 2020, dispose of the same by passing a reasoned order within 4 weeks after hearing all necessary parties, including the representative petitioners. A copy of the reasoned order shall be. All parties as petitioners say that they had got a rehabilitation plot number F6 as legal heirs of original awardee Bilat Maldar. We are the legal heirs of Bilat Maldar under Mahatma Gandhi Nagar colony measuring such and 6 decimals of land by letter number such and such of 2005. Opposite party said that they had got information report against plot number that Adijul Mahaldar is the 50% shareholder of plot number 6. This 50% we are disputing because he is not entitled to get 50%. He is entitled to get some person as legal heirs of Maldar. After, as per verification of the office records, Bilat Maldar was the land and the structure awardee of the share such and such, and compensation was paid to him against plot number such and such. Again, on verification of the office records, it is found that only structure payment was made to Adijul Maldar, son of Bilat Maldar, on November 8 against the plot number such and such. The chairman RSC means Rehabilitation Advisory Committee had recommended 6 decimals of land in favor of Bilat. That 6, my lord,
In on 2004, the RAC had rejected the petition of Azizul Maldar, son of Bilat, as land has already been allotted to the original awardee RAC resolution on 2004. The Rehabilitation Advisory Committee recommended rehabilitation plot measuring 6 acres in favor of Bilat, issued allotment in favor in favor of the legal heirs of Bilat. So legal heirs meant all the petitioners and Azizul too, Azizul also. Rightly. The RTI certificate issued by HDS, some factual error about the legal heirs issue is found. The Rehabilitation Committee is not liable for such erroneous RTI certificate. As per the compensation was paid without any compensation of land in favor of Azizul Maldar. So prayer of Azizul Maldar is hereby rejected as he was only structure awardee and no homestead land was acquired for him on account. So prayer for petitioner is considered and allowed. So my lord, the entire 6 decimals of land would go to the petitioners and Azizul. But he has been claiming 50% and disturbing our entry in the land. My lord, we are 6 here, 7 legal heirs of Bilat Maldar. One person, his son or brother, he has been occupying 50%, but he is not entitled to get 1/6. He is entitled to get 1/7. So, my lord,
Dispute is a private dispute between the
so
co-sharers.
they are the authority, my lord. They are the
What does the authority do? Authority has allotted in favor of all the co-sharers, all the legal heirs equally. Now, one of the legal heirs is fighting with the others. So the authority has nothing to do in this regard. It's a private dispute in fact. P1. Page?
So it was a misrepresentation. It was a misrepresentation by Azizul.
So it was allotted in favor of all the legal heirs.
No, but here, my lord, kindly column 2 right hand side. As per recommendation, page 20, as per recommendation of RAC dated such and such 2004, after allotment of the said plot issued in the name of Azizul and Bilayat Maldar, son of Abbas. Now that Azizul is my son, but he has been shown as my brother of Bilayat Maldar, and in that way he has got 50%.
So this is a
This was erroneous.
an error in the RTI. So the writ court cannot do anything about it. An error in the RTI reply, right? And the authority has allotted to all the
Yes,
legal
yes.
equally.
We are
So the dispute is basically a private dispute between the
we are now
co-sharers.
we are entitled to get money. All are in equal shares.
Given to you already.
But that fellow is not allowing us to enjoy.
Sir, it is a private dispute. The authority is not to be blamed.
So, my lord, the authority, we have last made the representation, page 50. Let the authority, my lord, to look into the matter, and
How can the authority help you? Please explain, sir.
that I was
The authority has granted you all that you wanted.
that
Now,
is
one of your family members is against you.
yeah,
So how can the authority help
he has
you?
committed fraud.
How can the authority help you? You have separate forums for this.
No,
Not
that
a court.
kindly, my lord, see the last portion of the 50. উত্তর রায়কে মান্যতা দিয়ে আরএসি গত 23 তারিখে সকলের বক্তব্য শুনিয়ে দিয়েছেন। 1 নম্বর বিবাদী আজিজুল মালদা শুধুমাত্র ঘর বাড়ির কাঠামো ক্ষতিপূরণ পেয়েছেন এবং বাস্তু জমির ক্ষতিপূরণ পেয়েছেন। উক্ত উদ্বাস্তু কলোনি বিলায় 10 উত্তরাধিকারী সমানভাবে পাবে। আজিজুল এর দাবি বা মালিকানা প্রত্যাখ্যানের অতএব মহাশয়কে অনুরোধ গত 19/6/23 তারিখে চেয়ারম্যান আরএসি নির্দেশ মোতাবেক যাহাতে মৃত বিলায়েত মালদা ওয়ারিশগণ সমঅংশে উক্ত জমির আইন মোতাবেক কাগজপত্র আদি পায়। So the paper should be handed up that you have got the land in equal shares. That if that is done, my lord, we will take recourse to.
That is declared already, page 25.
That has been declared.
Declared, everything is over from the authority side, I believe. Yes, Mr. Bandapadhyay.
Very much clear.
Yes.
And my kindly see once again the order.
Yes.
Authority has held in our favor.
It's a private dispute between the family.
Authorities have held, authorities has rightly held in our favor. And claim of Aziz,
Provisional offer letter issued, all this is in 2005. We are in 2024 now.
no, that 2005 manner erroneously, it was held, but it was given 50% to Azizul. But the Azizul has created all the problem.
So it is a private dispute, sir. I'm sorry, the writ court cannot help you.
Then my lord kindly make observations and dispose it of. So you can approach the civil court. Kindly you can make that observations.
Shall, instead of this, I have to dismiss on this ground.
Dismiss.
So there is no public element at all. So
Then
will you-
we are withdrawing.
I'll grant you liberty to approach the appropriate forum.
Yes.
Yes, that should be better.
That will be better.
Rather than dismissing it, it should
Yes.
be good. Affidavit of service. None appears for the state respondents despite service with about, I'm a regular resident. Keep. No.
Simple.
Affidavit of service, Rajshekar. None appears for the state respondents despite service. But, Mr. Bandapadhyay, copy service direction. The petitioners seek to withdraw the writ petition and approach the appropriate forum for redressal of their
The
grievance.
grievances.
Paragraph in view of the above, the writ petition being WPS such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioners to approach the appropriate forum for redressal of their grievance. Paragraph, there shall however be no arrest to costs urgent certified.
Just standing up, I was telling him, actually it will go to the civil court.
Purely a private.
Yes. I was telling him.
Next.
I'm grateful.
Sir, My lord, I appear on behalf of the petitioner. My lord, this the petitioner before your lordship lodge a complaint on the basis of the, my lord, this the,
Who is appearing for the respondents?
my lord, my learned friend is the private.
Private respondent, private respondent over 10.
My lord,
State?
I have
No, no,
served,
time for this.
my lord, I have served all the respondent and subsequent, when my lord, I mentioned before your lordship, I also, my lord, intimate.
But only for,
My lord, I have
There
come.
are other private respondent also.
Okay.
Whether my lord served or not, I don't know.
yes,
I'm appearing only my lord private respondent over 10.
no private respondent number 10.
No?
Asmat Raj,
Yes,
9.
9.
Where is the affidavit of service?
So my lord, this the, after my lord, the main, before mentioning, I have already served, they have received.
Affidavit of service.
Lordship. My lord, both the, my lord, is, sorry, my lord, I am not subsequent, I am not affirmed the affidavit, sorry. Only my Inoko spare is before your lordships.
Please, 1 minute, 1 minute. Where have you served the private respondents?
All,
Neil Ratan and Shomit Tikada?
all, sir.
No affidavit. This cannot be.
My lord,
accepted.
this the initial affidavit is there, my lords. I have first affidavit is there, my lord. I have missed the track report, my lord. That's why, my lord, further intimation has been given. So, my lord, this the after filing the writ petition, I have come to know the authority concerned has already, my lord, the fixed for date for, my lord, the demarcation. Because of that, initially I moved an application 144. So now on the basis of the report that it is found that the land is, assumption is this, my lord, the land is my land. Now subsequent on report, my lord, it has come to know that the land is belong to, my lord, the PWD. That's why, my lord, I lodge a complaint before the assistant engineer, my lord, fixed a date, my lord. This I have came to know just today, my lords, date for on 28th for demarcation. Unless, my lord, the demarcation is come forward from this authority, only, my lords, I am not humping, my lord, the Inoko sphere is the, let them to authority concerned to, my lord, consider the representation and dispose of the matter. Page, my lord, this is the last annexure. That is the only Inoko sphere.
Kindly come to their representation once.
Yes.
At the bottom, my lord, I can't find the respondent number 10's name is appearing. Only 1 and 2. Niloton Tikadar and Sumit Tikadar, as also in page 13.
Asmat Raj is there.
Asmat is not noted.
Yes,
Asmat
it's
is,
last. It's not numbered.
On number.
oh,
Sorry, my
yes.
It's not numbered.
typographical Xerox number.
Let this be considered.
Yes.
And demarcation has already been requested.
My lord, I have came to know, my lord, the authority
How
concerned,
came
not demarcated till now. Not demarcated.
Petitioner, my lord, is possessor is a private land. My lord, this is clearly private dispute. My lord, civil court has proper jurisdiction.
Position of private land, no dispute at all.
No, no.
In front of me.
Respondent number 9, my lord. Respondent number 9. Earlier occasion, my lord, move on application 144(2) of the executive magistrate. After accepting this application, he passed an order directing the police authority to maintain peace and tranquility of the area. Well, he government land. Well, how executive magistrate passed an order? This is purely private land.
Can answer.
Private land. Well, he is possessing. He is possessing.
Otherwise,
If demarcation shows that, then highway proceeding will go.
Consider Only after demarcation that
Then it will come.
Affidavit of service. None appears for respondent numbers
মারবে।
7 and 8
মারবে,
despite
অঙ্ক
service.
যেটা ভুল আছে।
The
না না পড়ে দিচ্ছি তোমার জেরক্সটা ওঠে না আমারও ওঠে
petitioner actually
জাজের কাছে
claims to be the recorded owner of the plot in question.
প্রথমে দেখা গেল প্রাইভেট লাইন
That
আবার
the
বলছে
private respondents
আচ্ছা,
are raising
জানি।
unauthorized construction by encroaching upon a portion of
ও তো
PWD
কত মামলা করলো ওটা প্রাইভেট লাইন, তাহলে ও জানতো প্রাইভেট লাইন, এখন বলছে ওটা গভর্নমেন্ট লাইন,
thereby obstructing their egress and ingress.
মানে ইঞ্জিনিয়ারও বলবে
The
গভর্নমেন্ট লাইন,
petitioners submitted a
Tailor ও
written
বলবে।
in this regard before the concerned authority on
ও যেটা বলবে সেটা শুদ্ধ।
August 2023 and prays for a direction upon
জানি
and
কারো।
pray for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the state respondents submits that
ফুড ফাইল
the
করে দেবো।
fourth respondent
Yes, yes, madam.
Fourth respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the petition is disposed of directing the fourth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, the petitioner and the private respondents, in accordance with law. It is disposed of which
Mala, it is found. Mala, that part is here, lordship is,
necessary because they'll initiate proceedings.
lordship, that part is only Mala record.
Not necessary.
They will take step in accordance with law. That part is you. That is
That's
enough.
sufficient.
That is.
There's no other option.
They-
This matter, your lordship, has to be served again because my lord, these are all that matter where my lord, service has not been completed as your lordship's direction was to serve up by name, but that has not been served by name.
Since service upon the alleged contemners is not complete, comma, let the matter stand over till 20th March.
Well, same.
Same order. Same.
Minus.
Same order. 51 also should be the same.
Minus. Same.
Same order.
Same one. Huh?
না না 752 তো কি করবে?
Your Lordship, Mr. Amitabh Mitra is appearing in a virtual mode.
My lord, in this item, pursuant to my last submission, we have filed an application for
Substituted service.
Substituted service.
You're muted. Mr. Mitra, you're muted. Please unmute.
টোট বুঝ শুনতে পাচ্ছে না তো আনমিউট। হ্যাঁ
respondent number 5 choose to appear and file affidavit in opposition. However, that is not on record. He had not filed. We have filed our reply. Now, this is a case allegation of plain fraud of the respondent number 4 and 5.
You wanted
Which
to
cannot
take
be-
steps for substituted service upon the
My
private.
lord, my lord,
Have you taken steps?
my lord, I have made this application before your lordship. Taking the prayer, kindly come to paragraph 14 and 15 of
Yes,
my
sir.
application.
application can one he filed and copy
Yes.
has served upon me also. Mother prayer
can
for
one-
substitute service.
Can
Can-
1 of 2024.
Can one my lord affirmed on?
Can one?
টা আছে কিনা? তোমার কাছে কপি আছে? ক্যান ওয়ান এর কপি আছে? নেই নেই নেই। কবে অ্যাফার্ম হয়েছে?
It was affirmed on Friday.
2nd February.
2nd February. 2nd February.
A copy was served, Mrs. and Mrs. and have you your copy? So
Yes,
kindly,
yes, yes, yes.
yes.
আমার কাছে আছে। এটাতেই কাজ হবে। Kindly take note of that copy.
And I have read 15 of the application at page 9.
Upon 4 and 5, let this be allowed.
My lord, my lord,
Let this be allowed.
my lord.
Because so far the state is concerned, the motor vehicle authority already filed
Yes,
its
yes.
after going through the same, and my lord, it fell from your lordship that since the my lord, the allegation of fraud, my lord,
From
is
the private
against the private respondent, and but he says that despite his best efforts, he was not
Yes, yes.
able to serve. So
I have annexed the
Please.
documents.
only recourse is the substitute service.
So I'm allowing the can to that.
And my lord, kindly pass an order to the effect of paragraph 15, my lord, because I have to attempt to affix following the principle of the Code of
Yeah, the
Civil
order-
Procedure, as well as I have to publish in 2 local newspaper.
Order 5, Rule 20 covers order.
Yes, 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 yes.
Stop.
Yes.
Can Heard learned counsels for the parties. Upon consideration of the submission made on behalf of the petitioner as well as material on record, comma, it appears that service of notice cannot be effected upon respondent numbers 4 and 5 in the ordinary manner. Paragraph, in view of the above, the application being Can 1 of 2024 is allowed. Paragraph is directed to serve copy of the writ petition along with annexure, a copy of the writ petition upon respondent numbers 4 and 5 in the substituted manner
My lord.
in terms of Order 5, Rule 20 of the Code of Civil Procedure.
My lord, kindly indicate, otherwise, Mala, he may have some difficulty.
Yes,
That including paper advertisement.
paper publication.
Paper publication. Otherwise, my lord, it will be
Paragraph,
difficult.
On prayer of the petitioner, liberty is granted to publish the notice in 2 local newspapers,
Grateful.
one in vernacular language and the other in English language, which are circulated daily, language, having wide circulation in the locality in which the respondents are last known to have resided or having carried on business or personally worked for gain. There are 3 components. Paragraph, let the matter appear under the same heading on end of March,
My lord, end of March.
28th March,
My lord. I'll come back with an affidavit of service of the publication. Grateful.
28th March. Yes.
In this matter, I'm appearing on behalf of the petitioner. My landlord is appearing on behalf of the respondent. My lord, today just I have received a copy of the report in the form of affidavit which
Copy of report.
Yes, my lord. Yes.
So this is the report, today, my lord, I'm a bit sorry. It is affirmed today and copy has been served.
I received it.
Because আমার copy কই?
তোমার লর্ডসের ফাইল
আমার copy কই? এটা আজকে affirm হলো।
আজকে এখন না কালকে এখন আজকে এখন ঠিক আছে।
You want to come back with an exception? Report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph on prayer of the petitioners, liberty is granted to use an exception to the report. Paragraph, let the matter appear under the same head. 8th March.
My lord. In fact, there is nothing, my lord, to place for any exception because these are all the, my lord, as per my lord's order that place the relevant notifications. So these relevant notifications have been annexed here to only thing. My আগেরটা কোথায় গেল?
Shaman, are you using an exception?
My lord, last occasion, Mr. Naik has completed his argument, my lord. They have been gone in the exception. Lord, nothing is required on our part, my lord.
The report has been filed by annexing interdepartmental communication, but no action has been taken. But this is very unfortunate. Your lordship wanted to have the action taken report. But kindly see, nothing has been done. I have stated on oath the number of auto rickshaws flying without operation, without vehicle, without permit, without any documents, registration. Kindly come to page 4, 5 at Galore, my lord.
It is a time-taking process. It will be continuing, but without taking step, 1,000 years continuation of this reserve will not come to the end.
Your objection is still pending?
I know. And report is unhappy. I am very unhappy with the report, my lord. Your lordship. Nothing has been stated. What am I to do, my lord? Interdepartmental communication, they are stating ITO says, ARTO says, maybe I. What about the illegal operation of vehicle auto rickshaws? You have to stop it. In the declaration, in the report, I have stated on oath regarding the number of auto rickshaws. Those registrations are also fake.
These are the number of auto rickshaws which are illegally registered, fake registration.
Not registered at all, use the fake number. After 2004, more new registration would be done according to the government notification.
Where is your objection?
Objection in the
Page 25.
Yes, 24 months start, 25. 25. They are backed by local politicians.
Let the objection be decided by the authority in terms of the numbers of the auto rickshaws that you have given. And if it is found that they are fake or illegal, the authorities will seize them.
Your lordship, kindly carry the board, not by the MBI or by the RTO. District Magistrate is the chairman of the board.
Will the board do it? Yes, who will do it?
Yes, my lord.
Who will do it? The RTO.
Number 3.
Regional Transport Authority.
Yes, that's the board. It's a heavy task, Mala. There the board consider, Mala. GM is the chairman. Let him consider, Mala. Otherwise, Mala, they stoppage or illegality. 3 number. Number 3. Board.
Exception submitted by the petitioner is taken on record, petitioners is taken on record. Paragraph, the primary grievance of the petitioners is that several auto rickshaws which are either unregistered or display fake registration numbers have been plying in several routes.
In route number 237, madam.
In route number 237, where you are also plying.
Yes, yes, madam. I have my permit, madam. I have my registration.
Where the petitioners ply their respective auto rickshaws on the basis of valid permits. Stop. Such illegal plying of autos is seriously affecting the business of the petitioners in the said route.
Now, the section
Otherwise,
section 69 clear provides a embargo. Can you see, madam?
otherwise it becomes a public interest litigation.
But I have made them because I have used the number of vehicles. I do because they are fake numbers.
Yes, yes. The petitioners submitted an objection in this regard before the concerned authority on the date of your objection.
My date of objection, my lord. That is my lord, 1st of April 2023.
On 1st April 2023, which is
My
yet
lord.
to be considered. Stop. The petitioners pray for a direction of the authority to consider the objection and take necessary steps for redressal of the grievance of the petitioners. Paragraph. Learned counsel for the respondents submits that several communications have been made by and between the authorities pursuant to the complaint made by the petitioners, and the authorities have taken appropriate action in this regard. The comprehensive report in the form of affidavit submitted on behalf of the respondents demonstrates that out of the list of 434 vehicles produced by the petitioners, only 2 persons appeared before the authority and the others did not care to respond to the notices issued upon them. Paragraph. Illegal plying of auto rickshaws is a menace to the society and is required to be curbed with a strong hand. Paragraph. Since the objection submitted by the petitioners is pending before the authority, the concerned authority being the third respondent hearing is directed to consider and dispose of the same upon affording reasonable opportunity of hearing to all concerned, including the petitioners, within 2 weeks. The board will sit, let it be 4 weeks.
4 weeks.
Because the board has to sit.
Rest number 3, my lord.
Yes, 3. Within 4 weeks from the date of communication of this order, in accordance with law. Stop. In dealing with the objection, the third respondent shall take into consideration the list of allegedly illegally plying auto rickshaws provided by the petitioners in the objection and
the report
take necessary steps for identification of the illegally plying auto rickshaws in the route in question. Stop. In the event such illegal plying is detected, comma, the third respondent shall take necessary steps in this regard within the stipulated time frame. Paragraph, since nothing further remains to be adjudicated in the petition, comma, the same is accordingly disposed of. I'll chattel and hope.
Your
Let us
Lordship
see.
indicated that in the objection as well as in the reports, exception report today, you kindly indicate, madam. There's some.
You have covered the same. It
Yes,
is
I have
covered in your objection.
Yes, sir.
The exception is covered in your objection. I've seen that. Next.
I'm appearing on behalf of the petitioner. Next 5 minutes also same identical. On 15 January, 15 January. File a supplementary affidavit. So now on that day, my lord, paid for time from file of acceptance.
The respondents want to, you want
No,
to
my lord,
file the exception?
my lord, on that day, my lord, he filed the, my lord, supplementary. But what I prayed before your lordship exactly that if there is necessity, because I could not go through the same because on that day it was served upon me. So I said that let me go through. If necessary, I can file.
So you don't intend to file?
My lord, no. My lord, I think, my lord, matter, my lord, can be heard and not disposed of, subject to correction, my lord, on the basis of the, my lord, the relevant provisions.
Yes, that is my case. Nothing else.
That is also relied upon by my learned friend also.
Yes.
Now, my lord, the case, my lord, in gist is that, case in gist is that the writ petitioner is the, my lord, a registered dealer. A registered dealer, my lord, of the, my lord, a two-wheeler manufacturing company and the agreement executed between them. So for dealership is concerned. After that said dealership agreement, applied for trade certificate before the concerned registering authority under Murshidabad. Number the concerned registering authority issued that trade certificate under Rule 35 of the Central Motor Vehicle Rules. And the issued certificate is, my lord, in terms of the prescribed form. Now, this validity of this certificate is for a particular period. Time to time, it is renewable. Now, the grievance is that a few persons who were also in the same trade, my lord, they were allowed by the trade certificate holder, the my development client, that you can act as sub-dealer. Later on, my lord, it revealed that those sub-dealer appointed by Mr. Khan's client, that is the, my lord, the original trade certificate holder, they also applied for trade certificate. And some of them already had been issued. It is by supplementary affidavit. Now his main question is, under the issue raised before your lordship is that a trade certificate can only be issued if, my lord, certain conditions are being satisfied by the applicant. Because trade certificate is for the purpose of, my lord, prior to the registration of the vehicle, he can do all these things on behalf of the purchaser. And, my lord, certain facilities are being enjoyed by the trade certificate holder. Now, his contention is that sub-dealers appointed by me, how can be, my lord, favored with trade certificates because they are not equipped with that certificate to be issued by the original manufacturer. Because according to him, and it is a fact, that condition precedent is that, suppose two-wheeler, original manufacturer, he has to admit first that he is my dealer. Then only that trade certificate can be issued on the basis of that application, and that section 35 is to be followed. Now, my humble submission is that since the question is this, now lordship kindly come to, my lord, the Rule 45.
Central rules.
Central rules. Central.
Yes,
Have you lost got it, my lord, 45?
yes.
Any person agreed by an order of the registering authority under Rule 35, that is issuance of death certificate, and my lord, expression is any person. Or Rule 44. Rule 44 is that the my lord, just previous rule, there is the provision for suspension or cancellation of death certificate. Within 30 days of the receipt of any such order, appeal to the head of the motor vehicle department established under section 213. All the motor vehicle officers are almost, my lord, appointed and got their, my lord, the designation under that section 213. Now, so there is a provision to prepare an appeal, because the entire thing is the read court cannot go into this, whether those documents are there, whether those documents have been annexed thereto, or that manufacturer is not a party to this proceeding, nor those particular persons in favor of
Several factual issues.
so
are
several
involved.
factual issues. So better when there is a specific provision, let him prepare an appeal, irrespective of the fact that those days are gone. No, my lord can say that the
That can be condoned.
yes.
No, that's what we consider. But my prayer, my lord, according to my lord, the Motor Vehicles Act and rules, for dealer is entitled only get the trade certificate. And the definition of the sub-dealer means as an agent or person engaged in dealing with the unregistered vehicle under the authorization of the authorized dealer. Dealer appointed by the dealer, sub-dealer cannot get the trade certificate. Now they made the application and they are getting the. For this,
So you are basically.
no, I have not challenged. Who had got, they got.
Basically,
So
issue is
authority-
whether legality or illegality or irregularity has been
No,
followed
what
or
that I have
committed
not
or
challenged.
not.
I have not challenged. I have challenged in future. Authority as a high
In
authority,
future,
they-
বলা
no,
মুশকিল।
application will make, they will act in accordance with the law, nothing else. Before grant of my lord trade certificate.
In
Because
future,
as per law, মানে only trade certificate is only.
So you
that
are
means you want a
dealer is
declaration.
entitled
That
to-
read
entitled
code
to
is
a
not a
trade certificate.
declaratory code. That in future.
That is the page number 8, my lord, rule 34.
Yes, you are challenging the issuance under Rule 35.
Yes, you challenge it.
You are challenging issuance of
So
certificates
that I
under Rule
modified my
35.
supplementary affidavit, because supplementary affidavit is a part of the writ petition.
Maybe.
I have modified my prayer.
কি modify করেছো?
So,
Prayer কি
what
করে
did you
modify?
modify?
Supplementary affidavit এ
Supplementary affidavit.
না কি prayer কি করেছো? তুমি দিয়েছো, ডিসক্লোজ করেছো, কাদেরকে দেওয়া হয়েছে?
কিন্তু তাদেরকে আমি চ্যালেঞ্জ করছি।
তাহলে উইথড্র করে নাও।
No, we take the
What is your modified
I
prayer?
modify my page number 6 in the supplementary affidavit,
Yes.
paragraph 7. My lord, there are, my lord, the manufacturer authorization certificate to the dealer on the basis of that trade certificate. Only the dealer is entitled as per rule 34. Only one dealer is entitled to apply for trade certificate.
Let that issue be adjudicated in a proper forum.
Any further trade certificate in particular violation of the provision.
Whether any violation has been made or not.
Let the appellate forum decide this.
Yes, let that everything.
I'll condone the delay part so
Yes.
that it is decided on merits.
Yes.
Yes? I'll send it to the appellate forum.
Yes.
Disposal.
Yes.
Yes.
I'll send it to the appellate forum
Yes,
for
yes.
disposal.
মানে appellate forum the writ petition can be disposed of.
তাই তো হচ্ছে দিয়ে অ্যাপিলে চলে যাচ্ছে।
Disposed of by sending it to the appellate forum.
The appellate forum. হ্যাঁ। ঠিক আছে, তোমার হবে, আবার হবে।
Heard learned counsels for the parties. The petitioners have primarily challenged an order of the registering authority issuing trade certificates in favor of some sub-dealers under Rule 35 of the Central Motor Vehicles Rules, 1989. Paragraph learned counsel for the respondents submits that the said order is amenable to appeal under Rule 45 of the 1989 rules and several factual aspects are involved in the matter which require adjudication before the proper forum. Paragraph. Learned counsel for the petitioners seeks a direction upon the petitioners submits that the matter be sent to the appellate forum for consideration of the same on merits without dismissal of the matter on the ground of limitation. Paragraph. In view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Paragraph. Liberty is granted to the petitioners to approach the appropriate forum. Right. Even in view of the above, the writ petition is disposed of. Dismissed for non-prosecution category is disposed of. Liberty is granted to the petitioners to approach the appropriate forum for redressal of their appropriate appellate forum for redressal of their grievance.
Better lordship kindly direct the petitioner to approach before the respondent number 2, because respondent number 2 is the higher,
Appropriate
director.
appellate forum, comma, being the second respondent hearing.
Yes.
Being the second
What should be the
respondent
full
hearing, comma, for redressal of their grievance. Paragraph. In the event the statutory appeal is preferred within 2 weeks.
কতদিনের করবে?
3 weeks.
Within 3 weeks from date, comma, the appellate authority shall consider the appeal on merits without dismissing the same on the ground of limitation. There shall, however, be no arrest to costs as in certified.
কতদিনের মধ্যে appeal শুনবে সেটা?
সেটা বলে দিন। After filing the appeal, so the appellate authority will decide the matter within 1 week from the date.
1
Oh, sorry, within 1 month or 3 weeks.
Within
Kindly-
8 weeks. Because the documents are to be, my lord, because all the records are in,
The appellate authority.
no, records are in Murshidabad.
Let there be no direction of,
Yes,
time. Let
yes,
there be no
yes.
time frame before.
Yes,
the
yes, my lord. Get.
Next.
It will better we shall approach.
Next time appearing,
For next
same order.
same order.
Same order?
7:06.
Same order? Ashok, same order.
Hey, Bapi,
759.
Same order.
Same order.
758 I appear, lord.
7:57 I appear.
7.
I appear.
Same order. Same order.
758 I appear, lord. এই সেম তো একই 59
Up to 7:59.
Yes. I appear.
7:59.
All in this matter, Mr. Borun Sound is appearing on behalf of the petitioner. He is engaged on division bench. So he requested me only to say for on the adjournment only for not today. Only for not today because
I'm appearing for the private respondent
Only for not-
only. Mr. Sen and Mr. Devra is appearing for the state government.
He's asking for not today.
Not today.
Not today.
3 matters.
Next one, those three.
No, 3. 60, 61 and 62.
62. Maybe tinte not today. All the 3 matters not today?
Two matter, Mr. Samant.
Not tomorrow. Not tomorrow I will.
You have difficulty tomorrow. There has to be a date. 60 and 61. These two are Mr. Borun Kumar Shamunto.
Yes.
The other one is a different Mr. Shamunto. Not the same matter.
Oh, that's a
You have seen only the Shamunto part.
So, Madam, this will be on Friday. This will be on Friday.
I'll fix a date. I'll fix a date.
Next Friday.
Next Friday, 9th.
9th.
9th. On prayer of the petitioner, the matter is adjourned. 7:60. 60 or 61.
60 and 61.
Let the matter appear under the same heading on 9th. February. Oops.
762 I appear for the respondent.
Petitioner,
Samanto is appealing for the petition.
where is he?
Well, kindly adjourn it for a fortnight.
Your report,
The report I shall file, my lord.
not
Yes.
ready?
No, my lord, there are, my lord, so many notifications, my lord, it has been requisition.
And so many extensions. None appears for the petitioner. Paragraph, learned counsel for the state respondents seeks further extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 23rd February. I'll give you some time.
20th, my lord, 20th.
Mr. Shamanto has come. But none appears to get in.
Right.
Miss the bus.
Next.
Ashwin.
Can be disposed of, my lord, in same term.
Same?
My lord, same pieces.
No. Hold on.
Mr. Sen wants to come back with a report.
দুটো matter dispose করে the same term, আমাদের same authority তো।
Let him come back with the report.
23 তারিখ রিপোর্ট ফাইল করে
Ashwin, ওই লাইনটা কেটে দিন। None appears to কেটে দিন। A petitioner, you're using an exception?
I have.
Yes.
The copy has been served. But may I find out the exception?
Have you filed any document to show that permits granted in 2016 were also permitted?
Your lordship kindly accept this, this exception I have given. Now, this is admitted from them, from their report. Your lordship kindly come to one of their report.
Yes.
Your lordship, paragraph 8, then paragraph 9, page 4 of their report. Furthermore, the notification published in 2004, so and so, the government so and so restricts arrival and departure and so and so from Babughat and only vehicles which are continuing to ply from the safe point prior to issuance of the safe notifications are allowed to continue the same. Therefore, the State Transport Authority, West Bengal, is not in a position to allow the prayer of the petitioner in any manner. Now, next paragraph. Even if the allegations of the petitioner to the effect that certain operators who had been granted permit in terms of the reciprocal transport agreement 2016 are flying their vehicles from Babughat is taken to be true. Such flying of vehicles from Babughat by those operators are illegal and unlawful. The answering respondents have time and again instructed the concerned police authorities.
Yes. So they are not supporting.
What? Your lordship can see. Motor Vehicles Department, Kolkata, to enforce upon illegal operation of vehicle by such hiring operators, and accordingly steps have been taken. Well, that is not there. Where what steps has been taken? Another contention is that when they told that intercepting those vehicles and imposing fine, that's enough. No. Well, if that has been done, then the provisions laid down in section 86 has to be followed, the cancellation of permit or suspension. Now, we'll also come to the
86.
section 86.
B.
Mine.
Not authorized by the permit.
Mine. then even my lord, in the report, it is admitted the interceptions took place and the fine imposed. But the thing is, this which are the vehicles?
But
Well,
your
it has
prayer is for parity. That cannot be granted.
Well, and this, well, my exception, I have given this. They have taken this stand that it has been done wrongly. If someone is operating, that is wrong.
So they cannot make another create and another wrong by granting it to you.
But I am not on that issue. My lord. Let them take steps accordingly because the steps has to be taken. Because, my lord, kindly appreciate one thing. These operators, those who haven't the permit to operate from Babughat, they are operating. And my lord, getting the privilege of that the passengers are boarding there from. So my vehicle, following the conditions of the permit, operating from Satragachi to be treated as the Calcutta bus stand, whatever. I am in loss taking the, because of the fact those are the operators. I am losing the passengers. Those who are operating illegally from that point, but I have a right to say all these things. So let them take steps and let them say these are the vehicles are operating and we are taking steps accordingly. This is the permit issuing authority.
The writ court can at best direct them to take steps under section 86
Minor.
1B
Minor.
in case of the erring
Minor in case of
vehicles.
In case of violation of any
Minor,
condition of
yes.
the permit.
minor. On my lord, your lordship, kindly allow me. If your lordship say, my lord, I can produce the number of the vehicle and even the my lord, the photographs by filing another my lord, supplementary an exception that these are till date, my lord, I can show that.
My lord, he has to file a public interest litigation
No,
because they are. I'm coming. My lord, one matter is still continuing before Justice Bosak division bench regarding terminal point I explained and Babughat. Ultimately, Metro Rail has situated a place for termini of all the buses. That issue is involved before the division bench. Mr. Samanto here, he also knows. I also appeared before that bench. So he has to appear additional party with additional party.
This is a different issue.
No.
It's the issue we are admitting. We are admitting here. Illegal cannot be continued. Illegal cannot be
So
continued.
if the
Well,
petitioner
if
wants
it
to
is-
give the specific numbers, that
Somebody can give it.
will help you.
My lord, that I am.
That's better.
Come back with
My
the
lord, my lord, I shall come back.
details of
Even the
vehicles.
photographs, those who are my lord, board is there. That is there.
But
From
details
Babughat.
of the vehicles
Yes, my lord. I
flying illegally or in contravention of the permit.
yes.
Learned counsel for the petitioner submits that several vehicles who have been granted permit in as late as in 2016 are touching Babughat which is the notification issued by the authority in 2004. Learned counsel seeks to use a supplementary affidavit furnishing the details of such vehicles.
Fine.
Paragraph, when can you come back? Let the matter appear under the same heading on 21st February.
My lord, it will take, my lord, it
What
will
time?
take some time.
It will take some time.
Any day in, my lord, any
March.
day in the March. Any day in the March.
6th,
My lord.
6th March.
My lord. But next is also identical. But this is two writ petition. One
764, same order.
764.
Vashu,
Same order.
same order.
in 764, my lord, I used my lord, the exception therein also.
5, 7,
This is my report. Partial to my.
765.
I'm.
Your lordship, last day.
I've already served.
No, well, the copy has not been handed over.
Report, copy not served.
No,
Today
I'm sorry, my lord. I
It is
prepared my-
affirmed today.
Today affirm, my lord.
You want to come back with an exception?
Well, yes, my lord, but in that event, my lord, I reserve this stay of the operations of this, sir.
No question of stay. It is taxing matter.
So in taxing matter, there is no questions of stay.
He taking
I have already
advantage-
furnished my lord bank
No, no,
guarantee
bank
there with
guarantee.
them.
That is undertaken before the authority.
So bank
Then
guarantee
you
with
will-
them. But
Come back
this-
next week. Come back next week.
Taxing matter.
So that in the meantime, my lord, let
Question of in the.
these decisions cannot be acted upon, my lord. These
Mr.
decisions,
Devroy,
but
please
that
give
that
necessary
has to be
instructions.
assured, my lord.
I'm not recording a stay.
Yes, my
But
lord.
please give necessary instructions.
Mr. Devra is there, I know. My lord, if Mr. Devra says not,
কি করেছে in the meantime?
The order should not be acted upon.
the order should not be.
কোনটা?
তুমি orderটা দেখে নাও না।
Report in the form of affidavit submitted on behalf of the respondents is taken on record.
ও confiscate,
Paragraph-
no, confiscate is there. Not record. Recording.
I'm not recording, but please give necessary
No, no,
instructions.
no.
Yes, yes.
That's
No,
exactly.
But I know,
No confiscation.
Devra is there, but only thing is that that's there now.
When matter is with me, my lord, I shall fully protected.
uh, On prayer of the petitioner, liberty is granted to use an exception to the report. Paragraph, let the matter appear under the same heading on 19th.
Come on.
19th February.
Mr. Mukherjee, please serve an advance copy.
My lord.
Yes, yes.
Next.
Right.
Yes, anyone for the petitioners?
কত রাখলো?
766. None appears for the petitioners. No accommodation is sought. Dismiss for default.
I am appearing.
Lord, I am appearing on behalf of the petitioner. I am led by Mr. Durga Prasad Datta. And this is the affidavit of service, my lord. Some of the petitions have come back. These are service upon the private respondents. Some have
Then
returned with the endorsement insufficient address and not known.
To serve again.
Lordship, the basic grievance is that
If it is refusal, I can accept, but otherwise. not.
I understand, Lordship. If I may just
Oh, there are several private respondents. Like that.
yes, there are quite a few.
Who are
Lordship,
they? Illegal tires. Who
Uh,
are they? The private respondents?
Lordship, these private respondents, they all hail from the districts of Hooghly and Bankura. They are having permits, but they are not supposed to enter the Kolkata Central Bus Stand. But the petitioners, they possess the permit to enter the Central Bus Stand. My primary grievance is that, or the petitioner's primary grievance is that they are all violating their permit
You're
conditions.
intruding into your rules.
Yes. And there is a specific state government notification I have annexed with this writ application. Lordship may
The
kindly.
private respondent, you're representing them.
of the private respondents drafted these.
Who are
Lordship,
these?
the-
Some, please tell me.
Yes, submit one thing, that is of the problem. And a lot of guys turn to page 52.
Service is not complete.
Consequently, page 52, matter is decided by the division bench, decided over picture. And pursuant to the direction, is still they are acting. 11th paragraph.
A PIL was initiated
Yes.
regarding
Page 54, adapt to assist the officers of the
The PIL was on the same issue.
same issue.
identical similar vehicles, they were violating their permit conditions. Now, in this writ application,
Page 54, 11th paragraph. In order to assist the officers, last officers will transport it. Deputy Commissioner of Police. Still continuing my.
But our specific instruction is that violation is continuing. Has not stopped.
Looked into by the officers of the police authority.
In
This
that
order has
case,
not
I would invite an affidavit from the state saying that this is being complied with.
Continue and police is acting.
My learned senior friend is there.
I'm appearing before the Honorable Chief Justice, this public interest litigation. My instruction is also that violation is still continuing and police is not acting at all.
Lordship will.
I find that the matter is pending before the Honorable Chief
Yes,
Justice.
it is. It is, Lordship.
I cannot deal with the matter like this. It is a
Lordship,
state issue.
in this writ application, we have provided a list. Lordship will.
Withdraw, sir. A same issue cannot be taken up by a single bench and a PIL.
No, disposed of. Disposed of any order.
No, 29th February is the next date.
29th
What
February. Yes, yes.
Yes, page 55 of the repetition.
Yes, yes. It is
It's
pending.
pending before the Honorable Chief Justice. This court cannot take cognizance of this matter.
And, would your lordships kindly
It's against
adjourn?
judicial right.
I completely understand, Lordship. If would it be your Lordship's pleasure to adjourn this matter till that matter is disposed of?
Very well. Let it go out of list.
One point may I take your lordship, maintenance of the writ petition in its present form.
Yes,
Maintenance of the writ petition in its.
I'll decide everything after the Honorable Chief Justice.
Can
decides.
adjourn it and maintenance point be kept open. I am appearing on behalf of the private.
The point is kept open after that.
Because the disposal of the PIL may solve this issue also.
Yes, Lordship.
I may, it will solve in fact.
Yes, it's certainly, certainly.
So let it go out of list.
Yes, and Lordship will kindly grant us liberty to mention the matter.
Affidavit of service. Paragraph 4, service upon all the respondents is not complete. Paragraph, in view of the fact that a public interest litigation with regard to a similar issue as in the present writ petition is pending before the Honorable Division Bench presided over by the Honorable the Chief Justice, let this matter go out of list. Stop, liberty to mention.
Grateful, ma'am. On the subsequent day, the state may, if required, the state may file a report regarding the
Let's
present.
see.
I'm deeply obliged.
I don't think it will be necessary.
Let's
But a
hope
very
so.
comprehensive order has
Yes,
been
yes.
passed, I find.
Yes, I'm grateful.
Next.
Lordship, I'm appearing for the petitioner in this matter. Lordship, I've served upon the respondent, but private respondent have not received yet. Lordship, I'm praying for a week time. Yes, Lordship.
Since service upon the private respondents is not complete, let the matter appear under the same heading on 5th March. Should be sufficient.
Yes, Lordship.
Next.
Grateful.
I appear to the petitioner, my lord. My lord, in this matter, my lord, service, my lord, some of the respondents have been served, my lord.
All are not served.
Are not served.
Very. Since service upon the respondents is not complete, let the matter appear and let the matter stand over till 5th March.
My lord.
Next. Petitioner.
My lord, this matter I am saying to withdraw the matter. I am saying to withdraw the matter, my lord.
Withdraw the matter.
There are some documents has been hazardly
settled.
No. Some documents has been wrongly endorsed in the.
So you're seeking liberty to file afresh.
Madam.
Please ask for that. If that is not granted, you cannot file again. Learned counsel for the petition. Learned counsel, the petitioners. The petitioner seeks to withdraw the writ petition on account of certain defects detected therein and prays for liberty to file a fresh writ petition on the same cause of action. Paragraph, in view of the above, the writ petition being WPA such and such is dismissed as withdrawn. Paragraph, liberty is granted to the petitioner to file a fresh writ petition on the same cause of action. Paragraph, there shall however be no arrest to costs as in certified. Next.
But I am for the I'm led by Shankarath Mukherjee.
Respondents? Served.
Led by
Respondents, who is appearing? Mr. Debra? No. Mr. Debra, are you appearing in this matter?
Sahab.
Who is appearing? No one. May I request you to appear? Service has been made. I'll regularize your appointment. Yes, what is the matter about?
This relates to curtailment of first applications made for curtailment that you'll also will find at page 19.
Page?
19.
Yes.
This has been given.
Perception.
It was rejected first time. I challenge the decisions and your lordship is find at page 27, my lord's order. One ground is that no opportunity of being heard was given, and that was only decided by your lordship. The second paragraph, the application has been decided by the RTO and assistant director, not by the board. But there are two things. One is the opportunity has not been given. Article 14 has been violated, audio altering party, and the decisions taken by not by the board, singly handled by the RTO and lordship set aside these decisions and remand it back to the authority for consideration. I will also kindly come to the order in place. That is at page.
No,
at page 36.
Page?
36. 36.
Please. 33 is your demand of justice.
36. 36. 36.
Yes.
Decision. Now, you'll also kindly see one allegation is there that they have served the notice for hearing, and according to them, it has been served and delivered within the period before the date fixed for hearing. So that is one allegation. Earlier pages, I produced some documents from the postal department that it has been delivered. That is page 31. It has been delivered on 13th of October 2023. Now, after the date fixed by the authority. One is this and it also appears from.
When was the order passed?
9th
October.
With that as is may you also can see. Then next
This
page
is
of
13th October. After that it was.
After that I received. Now, and 32, page 32. This has been issued by the department also. Dirghagram beat officer. That is the rural postal department. That the reasons for which the notice would not be served.
Yes.
That also should be given. That allegations, one of the aspect of that allegation that is cannot stand on that. But the next the decisions. Last decision of the STU board. Whereas the permit holder so and so applied before the so and so for curtailment of portions of Monsuka to Borda Chaukan from the existing route Monsuka to Howrah issued in permit number so and so. And whereas the Secretary STA rejected the prayer of the permit holder, and whereas being agreed by so and so, this is not the decision. And so the permit holder filed the petition so and whereas Honorable High Court directed, and whereas the data dated so and whereas in serial number 1, the second proviso of serial 1 in second proviso of subsection 3 of section 80 prescribed that the termini shall not be altered, and whereas the said applications of permit holder is asking to change the term. Hence, the considerations of the rejected applications for curtailment of the portions so and so in the route Howrah to Monsuka subject. I will also kindly see what the section 80 subsection 3. First one of the section 80. Now subsection 3, an application for vary the conditions of any permit other than a temporary permit by inclusion of a new route or routes or a new area, or by altering the route or routes or area covered by it, or in the case of a stage carriage permit by increasing the number of trips above in specified maximum extension, or by variation, there means comma, variation, extension or curtailment of the route or routes or the area specified in the permit shall be treated as an application for grant of a new permit. That's one aspect. Now we'll also kindly come to their allegation. Their grounds is that whereas in serial number 1 in second proviso of subsection 3 of section 80. Now subsection 3 of section 80 serial number 1. In case of variation, the termini shall not be altered and the distance covered by the variation shall not exceed 24 kilometers. Now with this, I put this question to myself, variation is altogether different with the curtailment. There the curtailment means either of the termini.
Shortening the same route.
Either of the termini has to be curtailed in curtailment.
Variation is a variation of the route.
But the variation in the termini shall not be altered. The route,
yes.
covering the route or area that has to be altered, and that should be within 24 kilometers.
Yes, that is
But so far as this is my contentions from the books itself, and this statute is very clear to that effect.
The authority
And
failed to understand the purport of this. Let Mr. Devroy respond to this. Yes. This is not a case of variation at all. This is not extension, this is not variation, this is curtailment. These are three separate things. An application for curtailment will be treated as an application for grant of new permit.
That is right, madam.
But this is in case of variation, which is not the case at all. The petitioner has not sought variation. So you want to come back, Mr. Devroy, after instructions? You want to come back upon taking instructions? Because this is for absolutely wrong. Yes, and it is permissible under section 80. The authority has failed to understand the purport of the section. The decision taken by the STA board in its meeting held on affidavit of service, regularized service, Mr. Devra service. In its meeting held on 9th October 2023 is assailed in the writ petition. Mr. Devra, another thing, one is this interpretation is wrong. Secondly, they say that the petitioner received the notice on 5th October. The resolution says 5th October. It was received on 13th October. From where did they get this 5th October? The second line of the resolution. Notice of hearing was issued, which was received by the permit holder on 5th October. Where is this consignment number? That has to be verified. Yes. These are the two aspects.
Mark.
You want to? It is recorded therein that the petitioner received the notice of hearing on 5th October 2023, whereas documents on record documents on record na kore, whereas the delivery manifest of the post office as well as the note of the beat office demonstrates that such notice was received by the petitioner on 13th October 2023. Stop. Also, though the authority has held that also, the authority has held that the termini cannot be altered. Termini, T-E-R-M-I-N-I, cannot be altered in terms of section 80 within bracket 3, bracket I, small of the Motor Vehicles Act 1988. So, the petitioner has sought curtailment of route and not change of termini as stated in the resolution. Paragraph, learned counsel for the state respondents seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading on First March.
Your Lordship has
Next.
19th, your Lordship has fixed another matter. 18th
18th February, I will not come to court. It's a Sunday. 20th? Very good. 20th. That's a different matter. That's a different matter.
But here only when the point of law has to be decided, nothing the factual has to be
19th. Yes, I've done it. Along with this learned junior. Along with this learned junior. Next.
This is under the Telegraph Act. We install, manufacture and install towers, telegraph towers. Under the mobile towers through which the connection is made. Now,
Respondents.
yes. Well, we served long back,
You're
3 weeks back, sir. My lord, now, my lord, whole thing is page 63, my lord. Page 63. The entire case is on this amendment with
Union of India also, I find.
no.
Are the necessary parties?
No.
The last respondent number 4.
We don't need any orders against Union of India.
They've just been.
So can their name be expunged?
Yes. Have you served or not?
Yes.
We have served the Union of India. Served though?
Yes.
Possibly. I mean, that's a little bit abundant caution, but
I'll just write. It's all.
well, page 63, my lord. This is on 17th August 2022. Rule 10B was brought in to the Telegraph right-of-way rules. The rules start at page 54. Now, Lordship, kindly see 10B, where the licensee proposes the establishment of overground cable, telegraph infrastructure over any private property. The licensee shall not require any permission from the appropriate authority. Provided that in case of establishment of mobile tower or pole over a private building or structure, the licensee shall submit an intimation in writing to the appropriate authority prior to commencement of such establishment. Provided further that along with the intimation, he shall also submit the details of the building or structure where the establishment or mobile tower is proposed, etc., etc. Now, appropriate authorities define page 54, 2B. Appropriate authority means central government, respective state governments or local authority, or such authority, body, company, or institution incorporated or established under the state government or central government with a property. Now, my lord, a guideline has come out on executive power. In excess of executive powers under the Telegraph Act, starts at page 100. This is called the West Bengal Telegraph Infrastructure Guidelines 2023.
Yes.
And Lordship, under this act, because Lordship will see this guideline, para 21A, it's under the Telegraph Act only. And Lordship will kindly see, we are concerned with this paragraphs 5 and 6 at page 103 of this guideline.
Yes.
5 and 6, 5. No person shall erect, install or establish telegraph infrastructure without obtaining prior permission from the appropriate authorities by applying through. So they do not distinguish private property and public. This is the first one, and Lordship will see kindly 6A1. 6A. One application for all telecom infrastructure development, deployment. If an applicant licensee intends to seek NOC or clearance or permission to install mobile tower or base tower station, or seek permission for laying optical fiber cable, then applicant licensee is required to fill common application form along with the prerequisite documents to be uploaded so and make online payment based on the proposed work. Proposed work, telecom infrastructure deployment by referring section 8 fees and charges through a unique portal. Single, but now logically comes to 6A1. In case of installation on private property, building and land, the applicant shall upload the following documents.
And Lordship will see regulation 8 here. I mean, what a regulation of paragraph 8, whatever one may call it, page 108.
তার আগে 105 টা দেখান that the appropriate authority will give the permission. 7. Okay. 7.
Yes.
And now 108, fee and charges. Towers, paragraph 8, 30,000 one time.
For each provider.
For each TSP, that is telecom service provider. So through one tower, if I'm servicing 4 telecom service like Geo and Vodafone, then I'll have to give twice over. Now, and the permission is that thereafter granted once I apply with the fee, then permission is granted under paragraph 7.
Page
105. The appropriate authority will examine, inquire, validate both new application and or request for renewal and dispose of on the basis of following salient features. Single window clearance made by the applicant, one time, so my application has to be, there's a deemed approval provision also 7A4. So application, approval, and in between comes the fees. Application with the fee, approval. Though I have said I'm going to maintain a separate writ petition, but I'm just covering it. Lordship kindly sees here, page 59 first. 59 first, my lord, 59. That is part of the right of way rules.
Yes.
Rule, sorry, page 58, 9. Rule 9 of the right of way rule. 9.1. A licensee shall, for the purposes of establishing overground telegraph infrastructure upon any immovable property vested in or under the control or management of any appropriate authority. So the government's property, state, central, local authority, etc. Make an application supported by such documents to that appropriate authority, such form and manner as may be specified by the appropriate authority. In this context, Lordship kindly sees 9.3, next page, at the bottom of page 59.
Yes.
Every application under subrule 1 shall be accompanied with such fee to meet administrative expenses for examination of the application and the proposed work as the appropriate authority may by general order deem fit, provided that the one-time fee to meet administrative expenses accompanying every application shall not exceed the amount specified in part 1.
This is binding on the state as
well. Of the schedule.
This is binding on the state as well.
Yes.
Right of way.
Now, Lordship kindly comes to
Page 65.
Page 65. Next page, page 60. Grant of permission by appropriate authority 10. Page 60, 10. I am on 10.2 at 61. Once again, it is reiterated. 10.2.
Yes.
Where the establishment of the overground telegraph infrastructure renders the immovable property vested in the control or management of an appropriate authority over which such overground telegraph infrastructure is established unlikely to be used for any other purpose, the appropriate authority shall be entitled to compensation for the value of the immovable property, either once or annually assessed on such rates as that appropriate authority may by general order specify, provided that the compensation payable for the immovable property for the establishment of poles for installation of small cells and telegraph lines shall not exceed the amount specified in part 3 of the schedule. Now, the schedule is at page 64 bottom. Part 1 is the fee at page 65. 9.3. 9.3 is page 59. That is for establishment of telegraph infrastructure over. 9.3. Yes. For establishment of overground telegraph structure, maximum is 10,000 rupees for establishment of mobile tower.
Not divided by telecom service.
And so one time maximum 10,000 rupees. But we have reserved our right to make a separate writ petition so far as fees are concerned, being beyond that what is prescribed in 65. But I'm confining this writ petition to the private property, that they have no right to levy. So now I'm going to install, so this procedure I should not be put to. This is the very short compass, subject to what my learned friend. With juniors, that's a problem. You can never remember their surnames. Mr. Chakraborty, what he has to say.
I'll rely on some provisions of the Indian Technical Act. The border review, sorry, I'm handicapped to that extent.
And the Bear Act. And Lordship kindly takes the Bear Act, which my learned friend wants to rely.
What are your prayers?
My prayer, Lordship, kindly come.
Kindly see the prayers. There's no scope for incidents. There's not a single prayer for interim orders. Because when you're practically asking for stay of the act or the policy of the government. By this, there's no interim orders.
That is your best point, Mr. Chakraborty. That's your best point. Lordship, I am asking for an injunction on them, restraining them from insisting upon any application for private on private property.
Which is not there,
There is no such prayer in your petition.
There's no prayer, man.
You should make a proper prayer communication.
There's no prayer to that.
I had meant the injunction separately. Injunctions.
You're only challenging the guidelines. That's
But Lordship will see prayer K, page 48. Interim orders in consonance with the prayers above. There should have been a.
Also.
Well, there should have been a prayer for injunction, Lordship. That I shall make it by a supplementary affidavit. This is after all writ court. But then this is a formal thing, Lordship. That I shall do it by tomorrow. It will be
Do
done.
you want to submit a report or something? Or?
Kindly see the provision of section 10. Because what is kindly see just now. Because today in the morning we have been briefed.
That's why I'm asking if you want to take an opportunity.
It will have some ramification. Kindly see section 10.
Section 10 of the Telegraph?
Yes.
Yes. Yes.
From that place and maintaining a typical line under, over, along, or a person who scheme or upon any immovable property. C, my lord. Except as hereafter provided, the Telegraph Authority shall not exercise those powers in respect of any property vested in or under the control or management of any local authority without the permission of that authority. Now kindly see 12. Any permission given by the local state property. Well, it does not restrict the act, the statute does not restrict it to a private or a public. Kindly appreciate, my lord. This is a portal, but I have asked the officers. The rules frame is a portal. Common
helps
portal.
us.
Yeah. When you are making this infrastructure, there has to be some permission because there are ramifications as regard to the pollution, as to the building infrastructure, whether the building can have that type of infrastructure or not. And just to come out and say that a private body, it cannot be extended to a private body, which is not contemplated under the Act. The Act says any immovable property, my lord. And it says the local authority, well, subject to correction, my lord, any permission given by the local authority has to be permission by the local authority. Local authority is also defined under the Act. Under section clause 10, clause C may be given subject to such reasonable condition as that authority thinks fit to impose. Well, that reasonability I have to go into. If I not go, well, there has to be an administrative expenses to that extent. Because if there is an application, all this all the authorities I have all the authorities I have a chance to communicate with them, interact and see whether this plan can be entertained or not. If today we are not saying that private party the private proportion cannot be done, but it's subject to correction, it's contrary to the statute. But kindly give me a 2 days time as there is no interim may I come back with better instructions from this? Because we will have some ramifications.
And by that time, supplementary affidavit, I shall be praying for my lord's leave to file. This is a slip. Or she made maintain his position, my lord, if it
I hope it will. Group 7 matters are not many, so it will not be difficult.
Thursday.
Difficulties with group 1 matters.
Monday, subject to my London senior friends. Monday.
No, group.
Monday night, roads night.
Affidavit of service, third learned counsels for the parties. On prayer of the petitioner, liberty is granted to use a supplementary affidavit in this matter. Paragraph, learned counsel for the respondents seeks to take instructions in the matter. Paragraph, let the matter appear under the same heading on 13th. Next week.
Before Saraswati Puja, good.
Yes.
13th court আছে কি?
Hearing matters.
7 inches the Gimpex matter. It may come back to my lord. I was complaining against the warfare charges, my lord, that had been imposed. I've given a bank guarantee and my goods are lying there and they are not allowing me to withdraw that bank guarantee. On the last occasion on my prayer, my lord was pleased to pass an order directing them to file a report telling this honorable court as to whether those goods were there or not. They have filed a report and we filed from that report, my lord. They say that the goods are there. Today, as of now, my lord, I'm just praying for two things. Number one, I want inspection because we find that the goods are less and we want to find in what state the goods are. And we want to take an exception to that report. Your lordship knows that provision is there.
The respondents? Yes.
But we are not asking for anything controversial.
No, the
just
inspection part.
inspection. They're obliged. It's my
shall I
goods.
Not today. Will you come back tomorrow?
Well, then for the time being, at least let me take out the exception to the report. Let me take the exception to the report. But kindly record my prayer that I'm asking for inspection, and because they are not there, the inspection is not being given today.
I'll just pass a direction for inspection on the next day.
Yes. On the next day.
Do one thing. Let me just make it not today, so that
Well,
tomorrow.
the exception, since I've been served a copy of the report, there is a time within which the exception has to be taken.
Where is the report?
I've told her. She says inspection order I can't get because the other side is not there.
Exceptions.
Kindly grant me leave to take exception.
Okay, sure. Yes. Report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph, on prayer of the petitioners, liberty is granted to use an exception to the report. Paragraph, the petitioners also seek an order for inspection of the
Goods, which the railways claim are lying there.
which, according to the railway authorities, are lying in their custody. Paragraph, the counsel for the respondents seeks accommodation. Paragraph, let the matter appear under the same heading on end of this month.
My lord, next week, my lord, next week.
16th.
16. My lord has granted me liberty to take out an exception. 16th.
I've recorded the inspection part.
My lord, I believe my lord takes it on Tuesdays and
16th is a Friday.
And Fridays.
oh, my learned friend is here.
Yes, ma'am. The report has already been submitted.
Yes, আমি বলছি আমি কি চেয়েছি আমি একটা exception to report চেয়েছি সেটি I want inspection. Well, he doesn't have any.
Seeking inspection of the goods. So when can that happen?
Any day, because it is not in the area, open area it is
Any day.
Any
Well,
day he can go.
Mutually fixed date.
Yes, yes.
We'll fix a date by writing a letter to them, and a mutually fixed date we will go and take inspection.
ওটা একটা লাইন অ্যাড করুন, অ্যাকোমোডেশনটা কেটে দিন। Learned counsel for the respondents does not raise any objection to such proposal. Paragraph, let the petitioners are at liberty to take inspection of the goods on a mutually decided date. Will it be prior? Let me grant you a little more time in that case.
My lord,
So
can
to
grant us
complete
2
inspection,
weeks. 2 weeks. Let it
yes,
come
so
after
the
2.
inspection is over by then.
And I shall file my exception also.
You will cover
in
that
the
part
meantime.
also in your exception. By the adjourned date. By the adjourned date. Or 16th Jaga. Let it be
Very well.
27.
Very well.
It's a Tuesday. Let the matter appear under the same heading on 27th February.
And our exception, if any, we shall take out by that date only.
And please serve an advance copy.
Very well. Grateful, my lord.
Next.
My lord, I'm for the SBSTC, my lord. So
My lord, I am for the petitioner, my lord. I'm praying for a not today in this matter. Being led by Mr. Chatterjee in this matter, my lord, he's on legs before some other court.
Mr. Devra, affidavits are exchanged. Yes,
Lord,
my
I'm not the regular counsel in this matter, my lord. I'm not aware of.
They are. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 5th March.
Gratefully.
March. Next.
Lordship, for the respondent, Mr. Singhania is appearing for Union of India. And if Lordship, please allow me to file a supplementary affidavit because AO has been
For the
filed.
respondents?
Yes.
You mean a supplementary opposition?
Opposition has been filed, supplementary affidavit, because we have missed one letter. That's very important letter.
Have you served?
No, I want to
Have
serve.
you served the other side? Supplementary.
Leave nichile. Have you taken leave?
No, Lordship has, I'm accepting. Let us not be technical.
No, normally we pray leave before filing. Let us proceed with the matter.
Are you ready?
No, and my senior is not present today.
Well, I want to conclude today. See,
Both the senior and junior is not present today.
There is not the junior.
And
Who are you?
I'm led by Mr. Nandlal Singhania.
You're the advocate on record.
No, advocate on record is not also not present today.
Hearing matters can never be taken up. On the last occasion, it was on your prayer, Mr. Vasuki.
I'm seeking for a very short adjournment, Lordship.
You're taking turns. That's what I mean. Prior to that, prayer of respondents. Supplementary affidavit submitted on behalf of the respondents is taken on record. Paragraph on prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 27th February.
Let us choose, my lord. Give some precedence so that 5 minutes matter. Very short.
Group 7 matters get precedence, no difficulty. There are not many.
না আমি তো দিচ্ছি
Next. 27 chapter.
State respondent.
Railways should be there.
Railways.
Since you are there, railways should be.
No, my lord.
Yes, railways would be there.
Mr. Shonajit Ghosh is coming.
Yes.
Oh,
Mr. Ghosh is coming.
he's the learned advocate. My lord, this is a matter, my lord. Matter pertains to everything. Paper book is there, my lord. So this is a matter pertains to, let's say, refund of the punitive demand which I have deposited on protest. There was an allegation of overloading against me at the Howrah station, man. Now, as the consignments, my lord, were expensive, so I have deposited a punitive demand, my lord. I've got released of the consignments, reserving the right to agitate the same before the honorable court with a prayer for rearmament of the empty weight of the wagon along with the tear. Now, my lord,
I approached before this Honorable High Court, my lord. The Honorable High Court initially granted me an interim order, which your lordship will find at page 61. 61 of the paper book. Yes.
Yes.
My lord, this is the order. My lord, kindly turn to the operative portion of the order, which is at page 63. My lord, kindly see Mr. Ghosh also relies upon a purported certificate of the Controller of Legal Metrology dated 27 July 2019, certifying that the in-motion weighbridge at Howrah Station goods yard is correctly functional. So she kindly mark these particular words, because I will be placing some documents contrary to it. Before commencing further on the merit of the writ petition, this court is at the outset requires the following formalities to be performed by the parties. The petitioners are directed to implead Controller of Legal Metrology as a party respondent. Let a copy of the writ petition be supplied to the Controller of Legal Metrology, the added respondent. The petitioners are also permitted to implead NFR as a party respondent. Let a copy of the writ petition be served upon NFR. On the next date, Railway shall submit the empty tier weight of the wagon in issue being number such and such. The empty tier weight of the wagon is to be taken in presence of the representative of the Controller of Legal Metrology and the petitioner. The other issues addressed at the bar, including the point of
only for the 1 to 5, my lord.
Yes.
I'm only for 1 to 5.
For the others.
These are the railway respondents, my lord.
Other railway is there.
They all. He is represented.
You have the
Legal bits.
As because, lordship, the order directs me to implead the legal metrology, and as because my learned friend has relied upon the certificate issued by the legal metrology, certifying that the in-motion weighbridge is functional correctly, that is the reason he has been impleaded. My lord, thereafter, my lord, this order was passed, directing upon them to conduct the weighment of the empty tier weight. And lordship, thereafter, what has happened, before such exercise could be undertaken, the railways themselves in the said writ application, said proceedings, my lord, filed an application seeking directions upon the legal metrology to rectify the weigh machines. My lord, that, lordship, kindly come to page 75 of the paper book.
But it's heard earlier.
Yes, my lord, I have already completed my submission. Only you are reiterating those facts, my lord. I will not take much time. This is the railways application. As you kindly see, it starts from page 66. And kindly see the prayer. Prayer is at page 80 onwards. The applicants therefore humbly prays, kindly see,
Yes.
to please to direct upon the concerned authority of the added respondent number 7, that is the Controller of Legal Metrology, weight and measures Government of West Bengal such and such, to take appropriate steps for repairing the said electronics in motion weighbridge at Howrah Station by giving permission for opening the seals provided on console units and junction box, and to pass any other or further orders which is deemed fit and proper. So my allegation, my lord, it was not functioning properly. That is the reason I approached before them for a reviewment. They didn't took any steps. I approached the High Court. The High Court passed an order. In the first interim order when passed, lordship has seen that they have said that it was functioning properly. They have also adduced the certificate issued by the legal metrology to that extent. And when the interim order was passed and when the time came for compliance, they came up with an application seeking a repair of the in-motion weighbridge over which that alleged overloading took place. Now, my lord, thereafter, I don't know what they did. They tried to, lordship, sort it out, and joint report was filed. Kindly see the page 89, the joint report. This is the joint report which was filed, lordship, in reference to, this is on 23rd of December 2000. And
Yes.
in reference to the above, we undersigned have jointly attended Howrah Goods in Motion weighbridge at 12 hours to witness the tier weighment of the empty VP of such and such, and found that the said weighbridge is out of order. These are, and this is a joint report. It has been signed by the legal metrology. So my contention was this: if the machine is out of order and if the allegation is on the basis of that particular machine that you have alleged overloading, I have not. Because it is the duty and responsibility of the railways, my lord, that before I load any consignment, their officers will have to supervise the loading and then they will allow it to get it dispatched. The rules are there. Now they themselves are in difficulty and they are making an application seeking repairing. And thereafter, my lord, the legal metrology's reply is there, which is at page 93.
Yes.
My lord, this is the letter which has been issued by the legal metrology to the railways, saying that with reference to the above, this is to inform you that the above matter lies sub judice under the Honorable High Court, Kolkata. The concurrent permission from the Honorable High Court, Kolkata is required for breaking the seals and opening of the console units and junctions for rectification of the said in motion railway bridge. So this further solidifies my case that the machine was not functioning properly. Now thereafter, my lord, in order to comply Honorable High Court's order, a second attempt was made. They asked me to attend the women process, not at Howrah, but at some other way bridges, which is appearing at page 109.
Yes. This is Dankuni station.
Dankuni station. Order was that to conduct the women at that particular way bridge. To this letter, my lord, I have objected that you have stated that it is functioning correctly. So any payment has to be done on that way bridge. So my lord, that payment did not took place. Now another joint report was filed, my lord, in this, which is at page 115.
Yes.
And here, my lord, kindly see what is this has been done in the Howrah bridge. After all, they have stated they have rectified. In reference to the above, we the undersigned have jointly attended Howrah Goods in Motion Way Bridge at 16 hours to witness the tear payment of MTVP and observed the follow. MTVP has been weighed at the electronic in motion way bridge and found to be 30.70 ton. Actually, it should be 32 tons. So, my lord, it is proved that the machine was not functioning properly, for which the overloading resulted. And there is a division bench judgment and single bench judgment. Lordship has well aware of that. I have placed those judgment. Lordship will.
So in motion way bridge is showing a lesser tonnage.
My lord, I need not go to that extent. I only have to show that it was not functioning properly when the incident happened. Because
goods should be also showing lesser weight in that case. If 32 is shown as 30.
30, obviously there will be differences. Because 32 capacity.
Lesser weight, that's what I'm saying.
Lesser anomaly will be there, my lord. And it was not functioning. I only have to demonstrate as far as the division bench judgment is concerned, my lord, and the single bench judgment which I will be relying upon. I only have to demonstrate that it was not functioning properly. And that has been done by the railways themselves. They tried to fix it up on their own. They could not do. That is the reason they approached before this Honorable High Court in the said proceedings by filing an application. They sought for rectification and repair. So that means when the incident occurred at that relevant point of time, it was not functioning. When it was not functioning, my lord, they are at duty bound to refund me the punitive demand. That is what the Honorable Single Bench in a coordinate matter has said, and the division bench has affirmed it. I am praying for a return of the punitive demand. Lordship, single bench order, Lordship, I have placed it on the previous occasion. Lordship should have the copy of, or else I will serve one.
Division bench order.
Yes, Lordship, before that, the single bench judgment is also there, my lord.
Yes, yes.
May I read, my lord, for once? Lordship, it the same thing happened there. In fact, the railway officials were punished with exemplary cost because without intimating the legal metrology, keeping them in dark, they tried to fix it on their own.
Yes, the single bench judgment is also.
Yes, the division bench judgment has affirmed and said that if it is found that the in-motion weighbridge is not functioning properly, then adverse inference has to be drawn and punitive demand as raised and deposited has to be refunded. And that has been complied, my lord. On that case, similar issue is here. So I have only to show that the in-motion weighbridge was not working properly. And railways themselves has confessed so. And legal metrology has also said the same thing. So punitive amount has to be refunded back to me in terms of the single bench judgment, coordinate bench judgment, and the division bench judgment. This is the only prayer.
Yes, Mr. Ghosh.
My lord, kindly come to the page 18, that is the prayer portion. And my lord, before starting my argument, I want to say that one point, and thereafter I elaborately submitted on that point, that their allegation was that machine was not, the TR weighment was not proper. And my lord, the machine was properly functioning at that point of time on 18th and 19th November. The cause of action arose on 18th and 19th November. But machine was, my lord, not functioning on 28th of December, 23rd of December. For this reason, my lord, they requested back. So, my lord, time is not the same.
Your letter.
Machine may be, my lord, that may be not functioning at any moment, my lord. That is a very big machine, my lord. So, my lord, that is not the proper, when that was the cause of action of this writ petition, that date was earlier, and that when the machine was not functioning, that is, my lord, on 28th of December. My lord, I have stated that. I am coming, my lord, on that point, my lord. My lord, kindly come to the page 18 of the writ petition, that is the prayer portion.
Yes.
My lord, prayer B. A is leave under Rule 26, then kindly come to the B. A writ in the nature of mandamus to issue upon the respondent authority, thereby directing them to carry out the weighment of MT 23 tons VP number such and such once it comes back in Howrah with the said train number such and such Kamrup Express from Dibrugarh as the same in round trip place van, parcel van for ascertaining its correct weight upon payment of usual charges. So, the first prayer for weighment, tier weighment of that particular wagon, that was complied by the order of this honorable court. Then kindly come to the C. A writ in the nature of mandamus due issue, thereby directing the respondent authority to take necessary steps in rectifying the motion weighbridge situated at Howrah, which is defective. At that time, there was no defect. Subsequently, that was defective and that was rectified. D. A writ in the nature of mandamus to issue, thereby directing the respondent authority to refund the punitive amount deposited with the railways to the tune of rupees 1,11,745. It is found that the tier of the VP number such and such exceeds the declared weight. This is very vital. Exceeds the declared weight. The declared weight was 32 tons. But after, in compliance of this honorable court, when it was weighted, tier weight was found, 30.70 tons. So, it was less than the declared weight. Declared weight was 32 tons, and it was weighted, empty weight was 30.70. So, now they are liable to pay 1.3 tons. But railway was not, billed for that. But, their allegation is not at all correct. Rather, there is another excess weight. It was found 1.30 tons. Then my lord, kindly come to the next page. 51.
Of the writ petition.
Of the paper book. I am submitting from paper book. My lord.
Yes, paper book.
Paper
yes.
book.
51.
51, my lord.
Yes.
My lord, kindly come to the top manifest. Your lordship got it. Manifest to be submitted by the leaseholder. My lord, that provision is under 64 of the Railways Act, and that is to be submitted by the leaseholder, not by the railway. And my lord, according to their voluntarily own declaration, the railway charge the fare, my lord. And their own declaration was, my lord, 1760 kgs. At the bottom, my lord, left hand side, 1760 kg. And my lord, kindly see to destination, top, my lord, right hand side, column number 1, 2, 3, 4, my lord. Various columns are there. To destination station Dibrugarh. Your lordship got it?
Yes.
The date of issue of MR 18 November 2019. Date of loading 19 November 2019. So my lord, that cause of action of 19 November 2019. And my lord, railway, that emotion way which was not functioning on 23rd December. That is more than my lord after 1 month. So my lord, their own declaration is 17,600 kg. That means my lord, 17.6 ton, my lord. Then my lord, kindly come to the next page. And according to their own declaration, that freight charge was paid, my lord. Page 52.
Yes.
Then my lord, kindly come to the next page 53. That is later dated 19 November 2019. Page 53. At the top right hand side, later dated 19 November 2013. My lord, the body of the letter, dear sir, in reference to the above subject matter, we had loaded 20 metric ton. My lord, kindly marked it. Page 51, their own declaration, 1760 kgs. 17,600 kgs. That is, my lord, 17.6 metric ton. But in the letter, they have stated 20 metric ton. Above VPH number such and such at Howrah station, but as per railway weight at Howrah station, showing 25,100 kgs, which is not acceptable by us. So, my lord, that they have not come there in clean hand. In their, my lord, the manifesto, they have stated 17,600 kgs. In their own letter, they have stated 20 metric ton. That means, my lord, 20,000 kgs. And my lord, it was found 25,100 kgs. Then, my lord, kindly come. The next page, 55. My lord, accordingly, my lord, that railway charge that penalty, my lord, for overweighment, my lord, that kindly see the date 19th 11 2019, my lord, and rupees 1,11,745. And they have paid that amount.
They're asking for refund of this amount.
Yes, my lord. Then thereafter, my lord, they have filed the writ petition and the first order, that is page 61, my lord. And in compliance of that order, my lord, kindly come to the page 63, my lord. That is the order of the Honorable Judge and Honorable Justice SUVRA Talukdar, my lord. The petitioner are directed to implement the controller of legal metrology as a party respondent. Let a copy of the writ petition be supplied to the controller metrology. The petitioner are also permitted to implement the NFR, that is, my lord, the North Frontier Railway as a party respondent. Let a copy of the writ petition be served on, my lord, I am not appearing on behalf of the NFR. On the next date, the railway shall submit the empty tier weight of the wagon in issue being number such and such. The empty tier weight of the wagon is to be taken in presence of the representative of the controller of legal methodology and the petitioners. The other issues addressed by the bar at the bar, including the point of maintainability taken by the learned Railway Council, shall be considered after the above recorded formalities are completed and presented before this court on the next day. So, my lord, on a very fast day, I have, my lord, raised the point of maintainability that they have not clean hand. In their own documents, in one, they have stated in their manifesto that 17,600 kgs, and in their letter dated 19th November 2019, they have stated 20,000 kgs, not 20 metric ton. And, my lord, we have complied the order of this honorable court on 26/11/2019, my lord. My lord, that order was passed on 26/11/2019. Then, my lord, kindly come. But my learned friend is hammering in my application of the railway that start from page 66. So, my lord, order was passed this honorable court 26 November 2019.
Of course, you'll need some time to make this.
My lord,
So
15
let me
minutes at
discuss the
least.
other matters for the day. Unnecessary.
স্কুল তো লাগবে না আপনারটা একটু শুরু করেন মানে নেক্সট ম্যাটার ইজ
Mr. Mitra cited some judgments, but it requires to service.
It's appearing tomorrow also.
Yes.
So why don't you give it tomorrow? Maybe misplaced.
মানে maximum 10 minutes, not more than.
I will reply, my lord.
No, the state is also there. So I think
Yes.
other matters released for the day. Continue.
Can I? Hello, can I? Item number 780 has mistakenly come into the heading hearing. 790.
Hearing matter.
790 is not a hearing matter.
This is hearing matter. Last of the my lord was on the
Last
affidavit
commission, my lord,
affidavit exchange regarding BS3, BS4.
No. আমি ওটা বলছি আজিমুদ্দিনটা বলছি আরিফুটা বলছি It was on the last time lordship passed an order to appear the matter on the same heading. The matter was in motion and it came under hearing. It was fixed to 790.
I'll find. Yes, continue.
Then kindly come to the page 66, that is the railway application. Page that starts from, and kindly see the rubber stamp of this honorable court for filing section, that is 2nd January 2020. So, my lord, the incident was happened on 19th of November 2019. This honorable court passed their first order on 26th of November 2019, and my lord, the railway filed this application on 2nd January 2020. Then, my lord, kindly come to the page 74, my lord. Under what circumstances the railway filed this application?
Page?
Page 74, my lord.
74.
My lord, I am placing paragraph 9, my lord. That under the aforesaid facts and circumstances, all arrangements were made by the concerned authority of the railway for weighment of empty tier of the said VP number such and such on 23rd December 2019 at 12 hours. And the all concerned authorities of the railway as well as the concerned authority of the legal meteorological department, government of West Bengal and the petitioner were jointly attended electronics in motion weighbridge at Howrah station to witness the tier weighment of the empty VP number such and such. And accordingly, a joint report was also prepared on 23rd December 2019, stating that in reference to the above, we the undersigned have jointly attended Howrah goods in motion weighbridge at 12 hours on 23rd December 2019 to witness the tier weighment of MTVP number such and such and found that the said weighbridge is out of order since 9.53 hours to 23rd December 1919 during weighment of one loaded VHP such and such leaseholder name National Carrying Corporation, weight shown 0, weight copy enclosed. Weight shown 0. In presence of ACM Howrah, AME, the undersigned have checked all seals provided on console unit and junction box and found seals are properly intact condition, but digital inside console unit shown 0 over range. However, VP number such and such has been weighted in both direction at the said weighbridge, but no weight indication was shown in the machine. On 16 December 2019, weighment of tier weight number such and such was not done due to non-availability of such VP at Howrah.
Hey, who is this? Yes, continue.
So, my lord, that in compliance of this honorable court direction, my lord, they want to wait it within that date, my lord. But it was not able as because that on that particular date, machine was not functioning. And my lord, the things is this in that machine, my lord, that if that machine will not functioning properly, in that case, if in motion weighbridge, anything will pass, they will show the machine will show the weight 0. That means, my lord, machine is not functioning properly. And my lord, from 19 November 2019, from the cause of date of occurrence, till my lord, 22nd of December 2019, my lord, various weighment was held. My lord, no one was, my lord, any complaint that machine was not functioning. My lord, railway, my lord, for their bona fide, my lord, their own says, my lord, machine is not functioning. And that date is very, my lord, on 23rd December. And my lord, I'm very sorry to say, my lord, that is, my lord, they are seriously trying to mislead this honorable court. That on 19th November and it is 20th December, the machine is not functioning. And their prayer was, my lord, for tier weighment of the wagon. Then, my lord, kindly come to the next page, 114, my lord.
One
114.
Yes.
That is, my lord, the letter of the railway, 13 January 2020. My lord, reference above in motion weighbridge of Howrah has been rectified. As such, as per directive of the Honorable High Court, Calcutta, White Order dated 26 November 2019 and 17 December 2019, tier weighment of MTVP number such and such to be done on date at 14 hours in presence of representative of yours and the petitioner. It is therefore requested to send your official on 13 January 2020 at 14 hours to witness the tier weighment of the subject VP at in motion weighbridge Howrah in compliance of the Honorable High Court's order. And my lord, kindly see the copy to the National Carrying and my lord, the all other officials, including the learned advocate of the petitioner and me, as a respondent's advocate, my lord. Then, my lord, kindly come to the next page, 115.
Yes.
Witnessing, that was, my lord, on 13 January 2020. Witnessing the tier weighment of parcel van number such and such at in motion weighbridge Howrah on 13 January 2020 at 16:20 hours as per order of the Honorable High Court in court case number such and such, National Carrying Corporation and another versus Union of India. Reference letter, ECM, and that is the letter. In reference to the above, we, the undersigned, have jointly attended Howrah Goods in Motion Weighbridge at 16 hours on 13 January 2020 to witness the tier weighment of empty VP number such and such and observe the followings. empty VP number such and such has been weighted at the electronics in motion web and found 30.70 tons. My lord, declared 32 tons. So, my lord, it is, my lord, some lesser. Some lesser means overweight is higher. My lord, excess weight, my lord, 1.30 tons. Excess weight plus that weight should be added as overweight, 1.30 tons. Because, my lord, 32 tons is the tier weight, and my lord, they have found 30.70. So 32 minus 30.70, that comes, my lord, 1.30 tons. And my lord, kindly see who are signed. My lord, all railway officials, as well as, my lord, at the right hand side, my lord, the bottom, my lord, the representative of the national carrying, my lord. Rubber stamp signature.
Yes.
So, my lord, my humble and respectful submission is this, that they have not come with the clean hand. And they have paid that penalty charges 1,11,700 and odd. And after that, my lord, they have taken the delivery of the goods. And in compliance of the order of this honorable court, tier weighment was done. So, my lord, what remains? So, my lord, now the question is, if, my lord, to find out the truth, then what was the actual weight of that consignment that is to be weighted? So it is not possible, my lord, after.
It's no longer there.
Not possible because that has been, my lord, goods has been taken delivery by the petitioner on payment of the penalty. And, my lord, kindly see the section 64 of the Railway Act.
Give you a minute.
Yes.
Yes.
That is, my lord, the page 51, that is manifesto. And that
Section 64?
manifesto, that page 51, that manifesto, that is, my lord, the forwarding note. That was submitted by the leaseholder himself. And that was also written in the manifesto also, my lord. Forwarding note, every part, my lord, section 64.
64.
Every person entrusting any goods to a railway administration for carriage shall execute a forwarding note in such form as may be prescribed by the central government, provided that no forwarding note shall be executed in case of such good as may be prescribed. The consignor shall be responsible for the correctness of the particular furnished by him in the forwarding note. The consignor shall indemnify the railway administration against any damages suffered by it by reasons of the incorrectness or incompleteness of a particulars in the forwarding note. The plea that failure to give, my lord, that is not related, my lord. So that is their own responsible to declare, my lord, what was the weight in the forwarding note, or that is in another name is called manifesto. That is their responsibility. And accordingly, my lord, railway, my lord, initially charged the rate, my lord. And, my lord, if it was found subsequently that the weight was not properly. So, my lord, when reweighment was held, in that case, my lord, the railway should, my lord, they charge the penalty for excess weighment. And, my lord, I am relying, my lord, two decisions, my lord.
Mr. Ghosh, will you continue some? I have a very important meeting at 4:30, so I have to rise today.
So then I will give a reply because whatever my learned friend has said,
Over.
legal metro,
Much to submit.
she fixes any date.
I will.
If possible, my lord, this week, my lord.
This week.
So, my lord, matter was earlier also heard. And, my lord, thereafter, a long time.
She fixes any date next week or any day subs.
heard learned counsels for the parties. Paragraph, let the matter appear under the same heading for further consideration on 20th February.
28th February.
We'll complete on that day.
Yes. I have a right of reply, my lord.
Absolutely.
Yeah, my lord, I have not yet completed, my lord, because
Yes, sir. Yes.